acknowledge the members of the Information Regulator who are like commissioners to us, Advocate Strom and Mpepete. I know most people won't understand that. So I will also acknowledge the CEO, the executives, and the colleagues. And the most important people to acknowledge are our guests for today. A warm welcome to all of you, and I'm just going to name a few that I have on our guest list. We welcome the Office of the Premier from Mpumalanga, Legal Resources Center, Emalahleni Municipality, Standard Bank, Direct Marketing of Association of Southern Bankveld Golf Estate, GCIS, Public Protector, South African Human Rights Commission, who is always working with us, and then most importantly, our community members from all organizations and structures. Can I ask you to give yourselves a round of applause for just showing up? I'm going to start by introducing myself so that it becomes easier to communicate with me as the director of the program. My name is Glenn Zulu. I am the CFO of the Information Regulator, and I'm going to be directing the program. So in line with our own POP here, I saw you at the front, you were signing in your names and giving us your information. So I just want to assure you that we will be processing that information for the purposes of this gathering. It will not be used for anything else. It's our portfolio of evidence of indicating that we did have this engagement. So nothing else, and we will make sure that we protect it within our custody. And then there's also other rules. You have a right to decline taking a picture. So what we have done is that we've got lanyards that you can use. The red means refusal to take a picture, and the blue means we can take a picture of you, and the picture can be used for any other communication documents in future. We will be using your pictures when you take them for the annual reports and the other documents that are related to our reporting. So if you are not comfortable with us taking your picture, do indicate by wearing a lanyard so that we can know that you are not fine with us taking the picture. Okay. And then the logistics, the bathrooms. If you need a bathroom, you turn left by the door and you go backwards where there is a dining room towards the bar. There are bathrooms there at the back for the ladies and for the gents. And we also cater for people with disabilities. So without wasting time, I want to open with a simple statement. Information is an asset. As our chair normally says, information is our new oil. If care is taken, information can go right and it can assist all of us. If care is not taken and things go wrong, where information is mismanaged, it can lead to litigation. So we are going to be discussing two pieces of our legislation, which is PAIA, Promotion of Access to Information, which is the legislation that deals with access to information. And the second piece of legislation is POPIA, which is Protection of Personal Information, which governs the protection of your personal information. So if PAIA goes wrong, we look like a secretive organization or secretive government, secretive state. So we lose trust in terms of our clients, we lose trust, and we're likely to face legal actions. And if information is denied access, then it means we are frustrating the community. So in terms of POPIA, if it goes wrong, if anything goes wrong with POPIA, we face fines or litigation or reputational ruin, and then we lose confidence from our investors. So by taking care of both these pieces of legislation, we are avoiding the bad. But Our role is not only avoiding the bad, is to ensure that we have operational excellence in all we do. So efficient organizations are able to deal with their information, and they have access to information. They know who keeps their information, who has a right to access to that information, and who can produce it, as well as disclose it when the need comes for them to disclose. So our gathering today is for us to take you through our annual performance plan so that you can close the gaps in the areas where you feel we have not indicated that we are addressing the issues that come with our taking care of your personal information. So we are relying on you, the questions and answers. We will present our APP targets, which is our annual performance plans, based on our strategic objectives. And once we have done that, we will give you an opportunity to ask questions. After each and every presentation, the executives will do that. Without further ado, I'm going to request the chairperson of the Information of the Regulator to give us the opening remarks. A round of applause for Advocate Tlakula.
Good morning. Can you hear me there at the back? Okay, Sanbonan and Huye More. It is so like, I'm not sure. It's as if we're attending a funeral. Dumelang hle, bagaetsho. Hey, that's better. Program Director, distinguished guests, ladies and gentlemen, let me stand on the protocol that has already been observed or established. My name is Pensi Tlakula. As I was introduced, I have the honor and privilege of chairing the Information Regulator. And as our program director has already indicated, I'm here with my colleagues, the two members of the Information Regulator. And maybe I'm going to ask them to stand in, because maybe, you know, when you were introduced, people did not see you, Mr. Kwala and Advocate Strom, and maybe face that way so that the people can see you. And of course, our boss, who runs this organization, Mr. Musalanyan Musala, our CEO. Can you also please oblige me? And the leadership of this organization, I think it's important to know them. Advocate Wikanyo, who's heading Popia, Mr. Dimba, acting Paia, Ms. Zondi, acting Education and Communication. We are not Hollywood, eh? You know? Well, we have so many people acting. There's a reason for that. And maybe the CEO will explain. And then we have Ms. Zulu here. We bow to her because she's holding our purse. She's the CFO. So with that, it's such a pleasure to be here and to see so many of you having honored our invitation, and I welcome all of you and those who are joining us online. And we are meeting during a very important month in the calendar of our country, which is Human Rights Month. And it is apt that we meet with you in this month because we are also a human rights organization. People forget that. They think we're an IT organization. We are responsible for two constitutional rights, the right of access to information and the right to privacy. And what is also important about this year is that is the 30th anniversary of the adoption of our constitution. For those who remember, it was adopted and it was signed by President Mandela in Sharpeville in 1996. So as the program director has already indicated, we are responsible for these two pieces of legislation. We have 5 members of the Information Regulator. We've got 2 vacancies as we speak that are supposed to be filled by the Portfolio Committee on Justice and Constitutional Development. They haven't found time to do that because they are busy with the ad hoc committee on police corruption. So we are all waiting for them to finish that job so that they can then fill in the vacancies. And so we are really here, and maybe just a little bit to say how the members of the regulator are appointed, because maybe you wake up and there's a person called Tlakula, you don't know how she became a member of the regulator. What happens in these processes is that the Portfolio Committee on Justice and Constitutional Development in Parliament will issue an advert in the newspaper to call for nominations. Once the nominations have been done, then that Portfolio Committee shortlists. In fact, they don't even do the shortlist first. If you go to the parliamentary website, you will see that for the 2 vacancies that I have spoken about, they've published the CVs of the people who have applied. There are 22 of them, and the public is asked to give comments on the fitness of those people to occupy this office. After that, that Portfolio Committee, there are 22 people who have applied. They'll shortlist, I don't know how many. They'll interview those people in public. And then after that, they take the 2 names to the National Assembly. The National Assembly must then vote for those names on a simple majority. After that, they give the names of those people to the president, who then appoints the members and the chairperson. So it's the same process as the Human Rights Commission, as the Gender Commission, as the Public Protector. We are appointed for 5 years, which is renewable. It doesn't say with all others, Human Rights Commission and others, they say renewable once, which means you can serve only 2 terms. With us, it just says renewable. So I can be here until I'm 90. You know, I can be chairperson for life because there's no term limit. So we started in 2016. That's when we started from scratch. We had nothing. We didn't even know. We were told you have to establish this organization. I had been fortunate because I had been in the group that established the South African Human Rights Commission in 1995 because I was a commissioner. But I was led by somebody, by Professor Bani Pichan, who was the chairperson at that time. So I had some little bit of experience in establishing organizations, but not as a leader. So we started, I remember, I always have to tell the story that I didn't know any of my colleagues. I met Advocate Strom as we were parking at the Department of Justice in the parking lot, and we looked at each other, says, I'm Lebogang Strom, I said, I'm Pensi Tlakula. And there we were in the boardroom in the Department of Justice where we were supposed to establish this organization. No office, no budget, no nothing. And that's how the whole thing started. And a few months later, the Department of Justice then gave us Ntate Musala, our CEO, who was an official at the Department of Justice. And there we started from nothing. And here we are 10 years. We have an organization that has almost 130 people, an office, a presence, and maybe it is known to some extent. Can you give us a round of applause, really? Because you know how things go in our country. Some people would still be holding meetings, a meeting about a meeting to establish. You know, there are all this, and a planning about strategy, about, then talking. Before you know it, time is gone. So here we are, we have been here. Our powers came into effect in just 2021, not too long ago, 5 years that the enforcement powers of the regulator have come into force. We are here today because we don't want to be one of those organizations that we make plans and people don't know what we are planning, why we are planning. That is why we are here, to share with you, to say this is what we intend to do. Where are the gaps? Can you tell us? On the issue of POPIA, promotion of the protection of personal information, on the PIA side, the promotion of access to information. And my colleagues will be taking you through those plans and to see where the gaps are. We are here. We came here because we don't have offices. So we thought, let's come here to talk to the people. That's what we do, because we don't have offices and it doesn't look like we will have because of the fiscal constraints. So we try to go to the areas of our country. So we are here, and also you'll tell us about gaps in our public awareness, education space, and Ms. Zondi will be telling you about that. We started with the Department of Justice. As part of the Department of Justice, we are now happy to inform you that we are no longer part of the Department of Justice. We are now a fully independent organization. We don't report to any executive. We report to the National Assembly. It's like that because we investigate everybody. We investigate people in the public sector, in the private sector. Some of you will remember that we also investigated the Department of Justice at the time when we were still housed in the Department of Justice, at the time when they were still in control of our budget. But we said we took a constitutional oath to perform our duties without fear, favor, or prejudice. And we found that they suffered a data breach, and we investigated them while housed there, and we fined them 5 million rands. Of course, we are in court with them regarding that because they are challenging us. And because we don't have offices, we're trying also to, keep up with the times, and that is why we have digitized our services, and our CFO will talk about that. The complaints that we received are so many, we are overwhelmed, both Popia and Paia. Very interesting complaints. I'm sure those of you who do not know us, at least in December, you knew us last year because we took the Department of Education, Basic Education, to court on the publication of matric results. We lost that case. We are appealing because we feel that an examination number is personal information, and we're not saying it should not be published in the newspaper. We say it can be, provided it's done with parental consent. So we are appealing that judgment. We are in court on the 12th of March, where the court will hear our application for leave to appeal to the Supreme Court. So that's who we are briefly, because I've been giving, I hope you are looking at my time, I've been giving 10 minutes. And with all that, I would like to welcome all of you, and I hope we'll have a fruitful time together. You must listen very carefully and take minutes, and take notes, because after Advocate Wiganyo and Mr. Dimba have given you presentations on Popi and Pai and the CEO, you're going to write an examination. And with that, thank you very much. Anyone, you're welcome most.
Thank you very much, Chairperson. Now I am going to request our CEO, and Tate Musala, to come and give us his presentation on our operations as the Information Regulator. A round of applause for Tate Musala.
Good morning. Chairperson of the Information Regulator, members of the regulator, distinguished ladies and gentlemen, mine is a very, very simple task. I am an administrator. I've been one for more than 40 years, and all I do is organize how people should work, and then people work. I do not do the work myself. The doers will come here and tell you how they've planned their work. For the last 43 years, I've been organizing administration. So I was fortunate to be approached by the Information Regulator way back in 2017 to assist with the establishment of the administration of the regulator. At that time, it was a secondment from the Department of Justice and Constitutional Development. I then came back as a full-time CEO. So I am going to just show you how we have organized ourselves to deliver on our mandate. So my presentation is about that, how we have organized ourselves to deliver on our mandate. So it's not about the core mandate. It's not about the day-to-day that we do. It is how we have organized ourselves. Like the chair has said, we have members of the regulator. They've already been introduced. And with the vacant positions, I'm not going to spend time on this. But we, as the regulator, we have a strategic view of where do we want to go? What is our destination? Where do we want to be? And we have come up with this ambitious vision of being a world-class institution in the protection of personal information and the protection and the promotion of access to information. And I normally use the analogy of an aeroplane, which I'm not going to use today, because it's only an aeroplane that can take you to destination throughout the world. Those of us who come from the rural areas who love horses, you can try and ride on your horse to Ghana, the poor animal will die. Those who like cycling, you can cycle and try to go to the Americas. You will not be able to reach. A ship will take you more than a year to reach the US, and so on. So we use the analogy of a plane that we want to reach the levels of performance of institutions like ourselves throughout the world. We want to be at that level of performance. And when we recruit our colleagues, we tell them that we do not want to appoint people who come with standards which are localized standards. Where I grew up in the Free State in Bloemfontein, there's a small little place called Forensics. And it's like Alexander. If you know Alexander in Johannesburg, I normally say we do not want the forensic standards. We do not want not that they are bad, but because we want to be a world-class institution, we want world-class standards. Our chairperson normally says we must put our best foot forward. And that's the kind of people we want to bring into the regulator. So our vision is a world-class institution in the protection of personal information and the promotion of access to information. How do we get there? How do we travel to this? That's our mission. How do we go there? Our mission, we want to go there being an independent institution. For us to realize and implement our mandate, we can't be located in any institution. We can't be under the control of any institution because we'll have trouble, like Chair said, of assessing them and finding wrong. We'll have trouble of saying who's responsible for what. Is it the chair or is it the minister? You know, you'll have those kind of discussions coming up. So we want to be an independent institution which regulates the processing of personal information and the promotion of access to information in accordance with the provisions of the Constitution and the two pieces of legislation that we have the mandate. Our values, how we behave in this journey of being an independent institution, we want to behave in a certain way. We want to ensure that those who are employed in the regulator behave in a certain way. And the first one, we encourage the value of transparency. We want to be a transparent organization that that's one part of being transparent, to come here and say, these are our plans, look at them, scrutinize them, criticize them, advise us on them. This is one way of implement the value of transparency so that you know what you are planning. We'll be telling you about our resources. That will be a way of being transparent about resources that are given to us and how we are going to utilize them. And we want to be an accountable organization. And through the governance structures that I will touch on, I will indicate how accountable are we to ourselves internally, how we are accountable to Parliament, to the Auditor General, but how we are, more importantly, how we are accountable to the people of this country, the taxpayers, those who mine to make an economy, those who make factories so that there's a strong economy, those who educate our children so that there's a future. We also account to them in terms of our dikopano and those kinds. So we want to be an accountable organization. We also want to be an organization that is run with integrity, where we measure integrity in terms of how we procure, integrity in terms how we deal with appointment of staff, integrity in how we investigate cases and how we come to decisions that we make around the cases and assessments that we do. So we want to be measured on that. That will be our behavior. We want to be an organization that prides itself with excellence. And it's one thing that is very, very close to my heart. I have a friend who's a pastor, and you'd know, pastors, I don't know, they have this way of saying things that none of us have. He normally says, if you are unable to do big things, do small things in a big way. And that's where excellence comes in, that if you can't do big things in life, do small little things, but do them in a big way. So we want the regulator, as small as it is, as new as it is, that it must be an organization that prides itself with excellence. Excellence, not just in terms of inner excellence, but excellence in terms of how other people look at us, how we perform. And a very good example of that is our CIO, who's the CIO of the year in South Africa. CIO, if you may. And as he shares our plans on automation, you will be able to pick up on this excellence that we are striving for. We're not there yet. We still are on a journey to bigger areas of excellence. So that's how we want to. We want to practice the value of impartiality. We want to be an impartial organization. We want to say, like Chair said, we can find the Department of Justice. We are not afraid to find them. We are not afraid to issue enforcement notice against big organizations. I'm not saying we have, but I'm just making examples like your big banks, your big institution in the private sector, in the government sector, and in all other sectors. So we want to be impartial. We do not want to be influenced by anybody. But more importantly, we want to be responsive. And this is what worries us as the regulator, the extent to which we are responsive. And we want to be honest with you that it is one value that at the moment we are struggling with. We are not where we should be. We are pushing that we should be a responsive organization. When people make inquiries about our services, we should be as responsive, as quickly responsive as possible. So we are not doing well in this kind of value, I must say. As much as we have pockets of excellence, we are well organized, but I think we are not as responsive as we want to be, and we want to be honest about that. We want to be transparent about that. It's where we're struggling. So these are our values, these are our behaviors, but how do we know that we achieve them? On a quarterly basis, I sit with the executives to do what I call performance review session. And each division comes and they tell me how they implement each of the values internally and externally. And they don't just write long stories, they also give example so that we're transparent on this day when we did this. And this is an example and they give portfolio of evidence. So we measure these values on a quarterly basis and we make them values that everyone in the organization should abide by. The most important thing is that we want to make an impact. We want to be an organization that make a change. And I'm normally accused by my colleagues of making examples. And I'm going to, on this one, I'm going to really call myself to order, not to make certain examples about impact. But we want to make a change. An impact is a change that happens once you've done something. It's a change that must come about, mostly a positive change. And our impact statement is all persons are empowered, and the most important word, are empowered to assert their rights. So for us to say we are fully a democratic country is when citizens of this country are able to assert their rights, are able to stand up and say, I would like my personal information to be protected, are able to say, I would like to know why this company came to this decision. I want to get information that they have at their disposal so that I can exercise my rights. So our impact, the change we want to make, is that we want to make sure that all persons are empowered to assert their rights to privacy as it relates to protection of personal information and the right to access to information. So that's the change we want to make. If you can see South Africans, more and more South Africans asserting their rights, then our democracy is working. But if South Africans are not asserting their rights, and in particular in the space where we are, in the dual mandate we have, then we are not making progress as a country. So that's the impact we want to make. We have two strategic outcomes that we pursue for a 5-year period. The first one is personal information is protected. That's the outcome, simple outcome. Personal information is protected. And the second outcome is access to information is promoted. These are our key strategic outcomes. So every 5 years, we will relook at these outcomes and check the extent to which we've achieved this. And the colleagues in education and communication will talk to indicators that are responsible to ensure that we measure these two strategic outcomes. But as an organization, when we build this organization, the first thing that is important is governance. Because governance brings order. Governance tell you what to do, what not to do with the resources at your disposal. Governance sort of say, you can spend this money, but you need to account for it. You can make this decision, but you need to own to it. You can challenge this, but you can challenge it in a responsible way. So governance organizes you. And all of us as people, we know that even in our personal lives, we need to have some form of governance. If we do not have some form of governance, then we become disorderly. So we've got statutory committees in the regulator, which are the first committees that deal with issues of governance. And the first one is the ordinary meeting, which is the highest decision-making body in the regulator, which is chaired by the chairperson, and the members are the members of that committee and is supported by the executives. So it's the highest decision-making body in the organization. It meets on a quarterly basis. I do not remember us missing a meeting. If we have in the last 10 years, it might be 1 or 2, but it meets regularly. And in that meeting, we go there as the executive and we account for the work that we do. So it's also a platform for accountability. You don't just work for the regulator and you do not account. But you don't just account directly at that committee. We've got what we call Section 49 committee. When you look at Section 49 of our Act, it provides that there must be committees of the regulator. So the regulator has established these committees. The first one is the Policy, Governance and International Cooperations Committee. It's a committee that looks at policy issues and policy positions that the regulator takes or responds to if there are policy decisions or policy statements made outside of the regulator. How do we react to them? Governance issues, planning, meetings, and those kind of things. International cooperation, we've got regulators throughout the world, and we have to cooperate with them. But we also have regulators in the country that deal with other aspects, which may have relations with us one way or another. So we deal with international and also issues around the country. The second committee is corporate services. The Policy and Governance Committee is chaired by the chairperson. The Corporate Services Committee is chaired by Advocate Strom, and that's where we go on to account for corporate issues, issues of leave, management, appointment of staff, money, all corporate services issues. We go and account to that committee as the administration. So we do not just do things, we have to account. Then we've got the Compliance and Monitoring Committee, where as we go around and assess and check compliance with different organizations, we go and account in that committee. We've got the Complaints and Investigations Committee. Obviously, people complain to us about how their personal information is processed or about how they are allowed to access information. We deal with those complaints, we investigate them. And then we've got the Education and Communications Committee. Section 40, Ms. Zondi will talk about that, provides that you must educate. And it's a big task, but we also need to communicate. So we normally communicate our decisions. And then we've got the Legal, Policy and Research. In this case, policy as in policies within the regulator. Legal, we are a legal person as an institution. We can be sued, we can sue, we can act against people, so we need legal. But we need to do research. We need to know more about the development locally and internationally. So we've got the research unit that deals with this. So these are the committees where the administration accounts to. And then you've got the Section 50 committee called the Enforcement Committee. It's a committee of independent members appointed by the regulator to look at matters that are referred to them from the POPIA division and the PAIA division that have been investigated and needs to go to the Enforcement Committee. And the Enforcement Committee, after looking at those matters, deliberating on them, they will then make recommendations to the members for final decision. It's an independent committee, but these are statutory committees because they are in terms of provisions of POPIA. So these are the governance structure in terms of the members. Then you've got other governance structures that provide oversight over the regulator. We know them, all of us. You've got the Portfolio Committee on Justice and Constitutional Development, where we table our APP, and we also go there to account for our work, our budget through the annual report. And from time to time, when we are requested to appear before the Portfolio Committee, we do that. We've got the Audit Committee that we have established, made of independent members who meet on a quarterly basis to look at our performance and to provide assurance that the work that we do is the work that is prescribed in terms of the Act and policies and procedures, but also the monies that we allocate to the work, or the finances that we allocate to our finances with allocating to the work. So there's the Audit Committee. We also have the Risk Committee. We all know that any institution needs to have a risk committee where you have identified your enterprise risks and you present them to them. But you also have divisional risks that each division will come up with and the mitigation plan. So you've got this outside the regulator oversight committees. And then we've got other structures that we've established that we work with. One of them is the Research Advisory Committee. I could think of one. I'm not sure whether we've got another, but I think it's one at this moment. Research Advisory Committee is a structure that allows us to, as and when we do research, we consult with the Research Advisory Committee because we're not trained researchers. We do not know how to start. We may have learned about it when we're studying at university, but we're not fully-fledged researchers who will know how to go about doing research. So whatever research we undertake, we take the proposals that we do to the research advisory. They'll look at it in terms of their skills and they'll advise us on it. So that this is another structure of the regulator. And then we've got what we call Section 47 committees of the executives, which is, we've got the EXCO that I chair as the CEO, and then we've got MENCO, which is the Management Committee of Senior Managers. But under each of these, we've got committees of EXCO that deals with various aspects. I'm sure you know about this. I will not spend time on this. The ICT committee, the skills development committee, and so on and so on. They are there. Almost every organization should have this kind of committees. I will not spend time on them. And lastly, program director, we want to communicate our planning cycle. A planning cycle is not based on the government planning cycle because government comes up with this planning cycle on the basis of elections. of national elections. Ours is based on the basis of the appointment of members. So from the time the first appointment was done, which was 2016 to 2021, it was the first term of office. So we planned for that 5 years. And we are now in the second term, which is 22 to 26. At the end of November, it will be the end of the second term of members. So the plan that we are going to share with you and discuss with you today is the last plan for the second term of office of members. In 2027 to 2032, we'll be entering the third term. So ours is not based on political term of office. It's based on the appointment of members, because we do not have to report to any political structure. With this program director, I want to end here and say this is how we have organized ourselves. There's still room for improvement. Thank you.
Thank you, CEO, Mr. Musala. I apologize that we are running a bit late in terms of time. I think the colleagues will indicate if the tea is available outside. But I think we can still take the questions from you from the presentation by Ubaba Musala. So Ubaba Musala basically ubezama ukukhuluma ngomsebenzi esiwenzayo as information regulator ngaphakathi ukuthi ama-operations ethu axhumana kanjani ukuthi akwazi ukusiza ukuthi uPhaya noPopia kube wona esiulawulayo esisebenza ngayo ezimthetho yethu yesisekelo. So ubezama ukuchaza ukuthi kuthathani ukuthi sikwazi ukuhlanganisa lowo msebenzi, ukuthi maningi ama-teams asuke ehlangene, kukhona u-finance, u-legal, kukhona ama-executives namakomidi abheka umsebenzi esiwenzayo. So in summary, I was just summarizing what the CEO was saying. So I'm not going to go through that again. So I'm going to just indicate that if there's any questions emanating from the presentation from the CEO, this is the opportunity to ask those questions, ladies and gentlemen. The floor is open. I don't know if there's a roving mic. You do have, okay. Is there any questions so far? Okay, I don't see any hands, so we will proceed with the next presentation, which is coming from Advocate Buganyo, who is going to be taking us through the protection of personal information, UPOPIA. That's what we call it, isibiza ngoPOPIA. So Advocate Buganyo, you have the floor. A round of applause for him.
Good morning to everybody, and the protocol has been established, and I, as the chair said, I also stand on the protocol that has so been established. As has been explained, my name is Tsepo Buikanyo. I am the executive that is entrusted with the division POPIA. We have indeed grown as a regulator, and this is also evidenced through some of the complaints that are being referred to us. I just want to say, without even getting into the merits of this matter, just say, Chair, that just last week, we had a referral from the Madlanga Commission relating to a contravention of the Protection of Personal Information Act. So we have, when we are recognized by other structures, it means that we have indeed grown as an organization. The slide that is depicted there is a slide that just shows you, just illustrates how we are formed. The CEO has already spoken about how we are formed, but there are divisions within the regulator. As the executive, I am the executive, and within the POPIA division, we have 3 subdivisions. We have the Complaints and Investigation Subdivision, that is headed by Advocate Zikishe. I want to recognize her presence also here today. We then have the Compliance and Monitoring Subdivision. It is currently headed by the Acting Senior Manager, Ms. Mbezi, Muhangane Mbezi. She is also in attendance here today. I want to recognize her presence. And the last subdivision is headed by Advocate Lamola. It is the Security Compromise Subdivision. And we will just give you a little bit of information relating to that. And then within these divisions, we have managers. And in each of those subdivisions, we have 2 managers each. And we have a number of officers. I'm not going to go into details with regard to that. I'm under very strict marching orders from the CFO. One of the things that as a program director, she has said that she knows that I can talk for the whole day. So she has specifically given me instructions to keep to the time. So I plan to do that, program director. The Complaints and Investigation Subdivision receives complaints in terms of Section 74 of our Act and investigates these complaints. Now, as part of our investigation, there's what we call pre-investigation and assessment of these complaints. And we attempt to, at the earliest possible time, to try and finalize these complaints that we receive. There are what we call simple complaints, and there are what we call complex complaints. And I'm going to spend a little bit of time because Mr. Dimba, in his presentation from our sister division, PAIA, is also going to talk about simple complaints. And I think and complex complaints. And I think I must just highlight and indicate what simple complaints are. Simple complaints are really those complaints that are straightforward that we receive, where within the POPIA context or in the POPIA context, there's an alleged breach of POPIA. And they do not require a full investigation. They require very minimal investigation. And they can really, these are complaints that can really be finalized very quickly, often through correspondence, clarification, or mediation. And the time frame for finalizing this is 3 months. We've allocated 3 months. And I can give you an example of what would constitute a simple complaint. It would be something, if we get a complaint relating to failure to update or to correct inaccurate personal information, we would classify that as a simple complaint because we can deal with that complaint fairly quickly. Then we have a category called complex complaints, and I felt I should just spend a little bit more time on this particular issue. Complex complaints would be those that involve very serious or systematic non-compliance with the provisions of our Act, which is POPIA. And they would require extensive investigations, and they would require gathering of evidence because they raise novel or technical legal issues. Sometimes they require expert analysis because we have IT systems or cross-border transfer of personal information or biometric processing of personal information. An example would be where we receive a complaint relating to unlawful processing of special personal information being, in this instance, health information as an example, or trans-border flow of personal information without adequate safeguard. So the difference would be with simple complaints, they don't really require full investigation. And with complex complaints, you usually are required to go the full investigation and the procedures the complex complaints sometimes culminate, or most of the time culminate in an enforcement notice being issued and an infringement notice being issued. So let's go into our achievements as a division, as the POPIA division. We have, over the last 10 years, we have conducted investigations across a number of sectors. And we have quite a few matters that are currently with the Enforcement Committee. When I saw Sergeant, I remembered Sergeant there that we have a matter that relates to South African Police Services, and this is the unlawful processing of personal information, where there was personal information that was shared through a WhatsApp message, and it's a matter that is currently before the Enforcement Committee. One other matter that there's an area that really bothers us, so it gives us sleepless nights as an organization, and that is the direct marketing issue. I'm sure all of you, as you're sitting here, from time to time you get calls from these direct marketers. And one of the things that there's a dispute that we have with the responsible parties, and this dispute pertains to our interpretation of what constitutes electronic communication. Our interpretation, our considered view is that telephones are included in that definition of electronic communication. Responsible parties do not seem to agree with us. So we've sent out a test case to the Enforcement Committee, and I'm not going to go into details around it. But the one matter, the first matter that we have, there are quite a number of matters that are in the pipeline, and we hope that if we are to get to a point of enforcement notice stage, we would then get to a point where we have a deterrence against such conduct, because we are aware that, and every time that we have gatherings like this, one of the issues that constantly comes out is the issue of direct marketing. So there's a matter of assurance that we have referred to the Enforcement Committee. And then there's the Companies and Intellectual Property Commission and Sanlam as an example that we have also referred to the Enforcement Committee. There are quite a number of assessments that we've conducted in the last 10 years or so across a number of sectors. We've conducted assessments in the insurance sector, we've conducted government entities, we've conducted it in the government entities. We've conducted all in all 35 assessments to date. And I'm going to go through the list very quickly through this list. And I see some of our colleagues that we have assessed are in the room here. And I'm very happy to see our colleagues that are in the room here. We have assessed within the banking sector, financial institutions, F&B, this related to security compromises, Nedbank security compromises, Standard Bank, influx of low-risk security compromises, African Bank, influx of low-risk security compromises, Capitec, security compromises, Investec, security compromises, and within the telecommunications and social media companies, MTN, we had an influx of complaints that led us to assess them. Vodacom, influx of low-risk security compromise and complaints that led us to assess them. Cell C, high-risk security compromise, and I see you, Mr. Piri, amongst us here, and thanks for coming through from Cell C. And WhatsApp, we had a concern with relating to certain what was contained in their privacy policy, and we wanted them to ensure that their privacy policy is aligned with the standards that they have within the European communities. And within the government sector, Department of Justice, you will be aware of that. Department of Basic Education, the chairperson has briefly touched on that. We have also the government entities that we've also assessed. South African Bureau of Standards, this was high-risk security compromise. South African Social Security Agency, International Trade and Administration Commission. We've also assessed insurance companies, insurance sector, as I've said. Sanlam was as a result of the influx of low-risk security compromises. Alan Gray, influx of low-risk security compromises within the retail sector. ShopRite, Home Choice, Truworths, and institutions of higher learning, UNISA and University of Johannesburg. So there's no sector that we've left out. We have gone out to assess all these sectors in instances where there was an instance of processing. We have also, you would know that the first fine that was issued was in relation to FT Rems, and because FT Rems did not pay the fine that had been imposed, which was 200,000, we are dealing with this matter in terms of Section 109 of POPIA, which then says to us that we can approach the courts and we can have this as a civil judgment. So essentially what Section 109 says of POPIA is that where a responsible party fails to pay an administrative fine, we can recover such fine through a civil action in a competent court. And so once imposed, the administrative fine is treated like a civil debt. So the regulator may take legal steps to enforce payment in the same manner as any other unpaid civil judgment. So that's what we are doing in relation to the two matters. This is the FT Rems matter and the Blowback municipality matter. You would also have been aware of, have noted in the media that there's also Lancet Laboratories where an enforcement notice was issued and an infringement notice was issued, culminating in them paying an amount of 200,000 rand. They have paid the 200,000 rand. WhatsApp, I've already touched on WhatsApp. We're in the process of finalizing the WhatsApp matter. We have signed a settlement agreement. We still need to reduce it into a court order. We need to find each other relating to some of the things that are contained in the settlement agreement, but we are almost at the point where we are going to find each other. I'm not going to touch much, and I'm going to put the CIO on the spot here because this is really something that is within his domain. The implementation of the complaints management system. We were really struggling because with the volumes that we are processing, and with the CIO coming on board, we are able to launch the complaints management system, and I'm sure CIO you will touch on briefly on the complaints management system, as well as the exemption application system that is really helping us as the POPIA division. We have picked up that there are gaps within POPIA, and having picked up that there are these gaps, I mean, after having had the enforcement powers coming into operation on the 1st of July 2021. When we assessed certain responsible parties, we picked up that there were gaps, but also in the investigation of our complaints, we picked up that there were certain gaps with regard to POPIA. This culminated in us going out and putting together a draft, the first draft of the amendments, which is still being processed. But just to say to you, one of the things, most of the responsible parties still say, even at this stage, and I can give you, these days, CEO, we're in the process of naming and shaming. When we wrote to the South African Football Association, they came back to us and they said, well, POPIA is still a new piece of legislation, so that's why we're not complying. POPIA is no longer a new piece of legislation. Our enforcement powers came into effect on the 1st of July 2021. This is 2026, and we, as a regulator, we expect that people should comply with this provision. So when we wrote to them, they said that POPIA is a fairly new piece of legislation, and we are saying that there are organizations that don't treat compliance very seriously with the provisions of POPIA, and a whole lot of these organizations have not even registered their information officers in contravention of Section 55 of our Act. I've already spoken about, so the amendments that we're looking at would be, for instance, that I always say this when I speak to my team, that POPIA is a very friendly piece of legislation. It's friendly because it affords you the opportunity of going out and correcting things before there's an infringement notice that is imposed. Now, we want to do away with that because people and organizations and responsible parties contravene the provisions of POPIA intentionally, and they know that there are no consequences. The only consequence is that you are then going to be afforded an opportunity of correcting that which you have contravened, and once you've corrected it, it's the end of the story. So there's willful disregard of the provisions of POPIA, and that is something that we want to attend to. So there's also, and the amendments will address that I'm talking about, will address that. They're still being processed, but I'm just saying that if you are a responsible party and you're sitting in this room, or if you are a data subject, you must know that the information that we're giving you is that there's going to come a time when there's a contravention, there's a direct fine that is imposed. And we are still in the process of processing these amendments. And then I've already spoken about the referral of the direct marketing matter. This is the assurance matter, so I'm not going to spend a lot of time on it. But I think the one thing that really poses a risk for us as the regulator is the number of cyber attacks that have been reported. And this was something that was reported in one of the online publications. In fact, it was in the Independent Online. The Independent Online is one of South Africa's online digital news platforms and media platforms. It was said in May 2025 that cyber attacks pose a very great risk than load shedding in South Africa at the current moment. And you will see the statistics. When we get to the statistics, I will indicate why I'm saying this. Let's look at these statistics. When we started off in 2021 and 2022 financial year, with 202 security compromises. We're able to finish 199 of these. In 2022, they rose to 590. We're able to finalize 544 of these. In the 2023-2024 financial year, we had 1,727 of these security compromises. We were able to finalize 1,493. For the 2024-2025 financial year, we had 2,374 security compromises. We were able to finalize 2,006. The 2025-2026 financial year, which is this financial year that we are currently in, we already have 2,898 security compromises. We've been able to finalize 1,578. Now, what is the message that is being shared here? The message that is being said here is that we may have responsible parties that do not have adequate security measures to protect the personal information that they hold. But more importantly, that the responsible parties may not be may not have the appetite, may not be having the appetite to put mechanisms in place to ensure that it protects the personal information that that they hold as responsible parties. The next slide really gives us statistics and the simple complaints that I've spoken about. We are currently sitting, as of the 1st of April 2025 to date, we are sitting with 1,681 simple complaints, and the complex complaints are 373. I've already explained what they are, simple and complex complaints. And the assessments that we've conducted during this period are 5, and exemption applications 4, prior authorization applications 8, personal information of children, we have 7, special personal information 6, applications for code of conduct 1, and information officers that are registered, we have 69,040. Now, this is a drop in the ocean if you consider the number of companies that are registered with CIPRO. Now, what is it that we want to do for the 2026-2027 financial year? Under complex complaints investigated and completed, we want 50% of the complex complaints will be investigated and resolved within the prescribed time frame. Now, the complex complaints are investigated within a period of 12 months. And under simple complaints, we want 70% of the simple complaints to be investigated and resolved within the prescribed time frames, and the prescribed time frame is 3 months. And then there's another indicator that we have of simple complaints resolved through conciliation and mediation. We want to do 70% of these simple complaints to be settled through effective dispute, an alternative dispute resolution mechanism, which is mediation. So, what is the reasoning behind these targets that we have selected? I'm sure you would have picked up the increase in the number of complaints. We've got a number of complaints, and the volume keeps on increasing. Unfortunately, the snowball effect of the work that we do in certain other areas is that we have these numbers going up. For instance, if our EduCom division goes out, or we go out on the Dikopano program, which is a program where we conscientize members of the public, and Ms. Zondi will say a bit more on that. The snowball effect is that people would come in and they would then register more complaints. Complex complaints, as I said, we are beginning to have these complaints becoming more complex, and some of them lead to a longer period to investigate. And obviously, the CEO has already spoken about some of these issues, and maybe the CFO, when she comes to do a presentation, will talk about our limited resources. We are, in Setswana, they say, in other words, we don't have enough resources to do what we want to do. So lack of also human resources, if you look at the capacity, the numbers that we have of investigators versus vis-a-vis the complaints that are coming, you'll pick up that if we had our way, we would want to have more investigators appointed. We've begun a monitoring exercise in terms of Section 40. And what we are doing in terms of this monitoring exercise is to write to responsible parties. One of the criticisms that is often leveled against us is that as a regulator, we come in after the fact and we come in wielding a stick when we come in. So we have decided to proactively engage with our stakeholders, and the responsible parties are also our stakeholders because they are affected by the decisions that we make. So we've decided to interact with our stakeholders. And what we do is that we do a random sampling across certain sectors. And what we then ask these particular responsible parties that have been sampled to give us proof that they are complying with the provisions of POPIA, the 8 conditions and regulation 4 of POPIA. So you can call this friendly fire, because we don't go in, Mr. Nkonzo, you can pass this message to Standard Bank that we don't go in with a stick. We are going to afford you the opportunity to demonstrate to us how you're complying. And I think one of the issues that was raised, CEO, when we were in Parliament, they were reporting to Parliament, is that we don't proactively interact with our stakeholders insofar as some of these matters are concerned. And this particular exercise will also assist us in getting a feel of how the responsible parties are complying with the 8 conditions for the lawful processing of personal information, and also specifically with regard to the regulation 4. We also have we're trying to finalize the code of conduct on gated access. It's still being processed by the members. We had a very cordial stakeholder engagement with our stakeholders, where certain things were suggested to us insofar as the code is concerned. But maybe the question, I should just pause and say the following, that what we're trying to address in this particular code is the protection of personal information that is collected and processed in residential areas, the gated ones, gated complexes, business parks, or in all the gated establishments. I'm sure most of you, when you entered this hotel here, at the security gate, you had your personal information that was processed. There's a machine that they have, and what they usually do is they look at it, take down your registration number, and then they go to your disk and they scan your disk. We're looking at some of those things to ensure that the objects really of this particular code of conduct is to regulate how access control systems, such as your biometric systems, your CCTV, your visitor logs, and your vehicle registration systems collect and use personal information. Also to ensure that there's overall compliance with the provisions of POPIA. Also to protect visitors, you as visitors, contractors, residents, and employees from excessive or unlawful collection of personal information, and to promote transparency and prevent misuse or over-retention or unlawful sharing of personal information. I'm going to pick up speed, CIO. I see you looking at me, so I'm going to pick up speed. Some of the challenges that we are experiencing as a regulator, and specifically as the POPIA division, are the increase of complaints. I've already highlighted the increase of complaints, but we are also struggling because complainants don't seem to be able to properly complete Form 5. The Form 5 is the form that you use when you lodge a complaint. They sometimes submit incorrect forms for the purpose of lodging a complaint, and there's just overall low compliance by public bodies. Complainants also approach us, the remedies that they seek from us are remedies that are not in concert or that are inconsistent with the provisions of POPIA. Under the compliance and monitoring subdivision, we have the issue that we've picked up is low levels also of compliance by specifically by public bodies. And I need to qualify this and say, we have seen and we're encouraged by the compliance by the private bodies, but I think we can do better within the public sector. And we also have a failure to implement policies by responsible parties. Responsible parties on paper have very wonderful policies, but they do not implement those policies that they have on paper. Security compromises, I've also touched on security compromises, the challenges, the increased number of security compromises, and generally the safeguards, inadequate safeguards that are put by the responsible party in protecting the personal information. So what have we learned a few years on as the POPIA division? POPIA has given us experience, and when we consider these matters, the complaints that are considered at the level of the members also, because the members make the final determination with regard to complaints. So the scheme of things would be that there's a complaint that is processed, it then goes to the enforcement committee, which is an independent committee. The enforcement committee would make recommendations to the members, and the members would finalize the complaints. But if you have an assessment, the assessment goes directly, once the division has finalized the assessment, it then goes directly to the members, and the members would finalize it. So there are a lot of experiences that the members have picked up, and that we have also picked up as a regulator. And it has also enhanced our knowledge with regard to the provisions of POPIA. So we have direction, clarity, and certainty in interpreting the provisions of POPIA. The year ahead, this year ahead, we will focus on intensified investigations into non-compliance with POPIA. We'll targeted assessment and ensure mature, integrated, and future-ready compliance practices that are in place. From the monitoring exercise, and this is something that we've conveyed to the members of the POPIA division, if in the monitoring exercise we pick up that there are contraventions of serious contraventions of POPIA, we will then go in and assess a responsible party. So the encouragement would be to the responsible parties that when we write to you as part of the monitoring exercise, please respond to us so that we don't then go to the next level, which would be the assessment level. Because if you don't have anything in place, and some of the responsible parties ignore the information regulator, if you don't have anything in place, then we'll go in and we'll assess you, because you have an obligation as a responsible party to also protect the personal information of data subjects. With that said, Program Director, I hope that I have not taken too much of your time. Thank you very much for the time that is allocated.
Thank you very much, Advocate Wiganyo. We are opening the floor now for questions and answers. I know that there is our audience, the stakeholders online who are virtual. I'm not sure if we are ready for those questions as well. Please do take them into consideration, EDUCOM team. There is a question right here. Thank you very much.
Good morning.
Okay.
Kindly introduce yourself again when you take the floor, so that we can know who to respond to.
Good morning. Good morning to Chair, CEO, and all advocates. I'm David Dickens. I'm the CEO at the DMA SA, Direct Marketing Association. It's always great to come and get informed through the stakeholder engagement. I have one question and I think a statement. We look forward to the outcomes of the telemarketing issue, because like every book, advocate said that it is kind of an issue that we'd like declaration on to make it clear. Our members, we have over 250 that would like guidance, and we can help them quickly implement. So if we can get a time frame when that would come out, or kind of a ballpark. And also, when will the office really be occupied? Because the DMA has submitted its code under Section 60 as the biggest institution to have its code recognized. We've sent it twice, it's come back. We have 5 fixes that the regulator team has asked us to do. We'd like to resubmit it, but we'd like to do it when it's settled and when they're ready to receive us. But yeah, we look forward to it. So yeah, those are my 2 areas.
Thank you very much. There is a gentleman there at the back.
Okay,
Okay.
good morning. My name is Wanani Sitsula. I'm from the Consumer Goods and Services Ombud. I just wanted to find out, does the regulator have any plans to mitigate the risks involved in artificial intelligence. And then I also wanted to find out, or just would like to hear, what the regulator is perhaps doing in terms of moving organizations from paper compliance to actual compliance of the data that we are processing as organizations. Thank you.
We've noted your hand. They will come to you with the mic. Gentleman at the back.
Right, good morning. Good morning, everyone. Thank you so much, regulator, for inviting us. We definitely don't take the opportunity for granted. I've got two separate questions. The first one, I think it's for the COO. He made that wonderful analogy of if you're coming from the village and you're now running a regulator. It just resonated with me because I'm also from a rural village in KZN. It's a place that probably no one has ever heard of. It's called Nsuze, but it's a rural village, yeah. But when it comes to best practice, because you're saying now how the regulator sees best practices, that you should have regard to international best practice. But I wanted to understand practically how is that unfolding? Because when I look at POPIA and some of the basic teething problems, for example, no definition for a compliance framework and no definition for a person information impact assessment, and various reasons have been given for that. But my thinking around that is that there is best practice that could be used to get those definitions. And the definition of a compliance framework is critical, because if you don't, everyone has a different understanding of a compliance framework. Some organizations are saying, look, this compliance framework, it needs to be POPIA specific. My interpretation is that a compliance framework is actually an institutional document that governs compliance in general, not just POPIA. But there's different interpretation, and both sides of the fence have a legitimate point to raise. So I just want to understand, at what point do you consider existing best practice, your King 4, your GACP, which is generally accepted compliance practice for those who don't know? And I also understand the sensitivity that you don't necessarily want to align with any particular institution, but that's not my point. My point is there is best practice. Why don't we use it? It's South African. It's used by the banks. It's used by insurance companies. It's used by the public sector. So why don't we use it and incorporate it? The second part of what I wanted to understand, and perhaps this is just for my education and for others who are interested, you mentioned the security compromises, and it seems a lot of that is coming from, you mentioned the investigations, and my understanding is that most of the investigations are instigated by security compromises. Okay, I get that, but why are you not investigating other areas? And you'd have to educate me, because I don't know the answer. For example, why are you not investigating lack of compliance framework, lack of impact assessment, etc.? Because the way I understand it is, a security compromise, it doesn't really take place in a vacuum. It's a microcosm of section 19.2, which says you must do an internal risk assessment to personal information, another risk assessment to external risk to personal information, etc. So there's a linkage there of like compliance fundamentals that seem to not be tested. You can test a security compromise fine, but there's actually a root cause, and I'm just trying to understand why you're not testing other areas. Then the last question that I have relates to assessments. You said that you've had about 376 complex complaints, roughly, okay? And then you're saying you've only done 5 assessments. So again, I'm trying to understand why the variance. If you've got so many complaints, which are complex in nature, but then you only have 5 assessments, I mean, those are disproportionate. And I'd just like to understand the reason for that. Surely if you've got 376 complex complaints, then you want to raise the number of assessments that you do. But again, I'm sensitive to the point that you resource constraint, etc., and you're building, etc. And then the last point that I just want to mention is that as the regulator, I think you should be proud of the work that you do, because you're a new body, you're under-resourced, and you've done fabulous work. And that's something that you must take to heart. Don't just criticize yourselves and allow people to criticize you. You've done fabulous work. I can vouch for that. Thank you very much.
Thank you very much. I think I missed your name, Mnumzane waseNzuza, ugcina ungasitshelanga igama lakho.
My apologies. So my name is Stephen Ndlovu, and I'm a compliance strategist at Gajeni Advisory. My apologies for not introducing myself properly.
Siyabonga, Gaje.
Siyabong.
Okay. Can we just take those first round of questions? We'll come again to the second round. We don't want to miss your questions. So the team, Popia and the rest of the Information Regulator executives will assist with the responses. Advocate Wikanyo.
Thank you very much, Program Director. And I also have the senior management team and the members of the regulator also here. But maybe just to correct something, Mr. Ndlovu. We've conducted 35 assessments and not 5 assessments. You may not have understood the presentation, and the assessments are through quite a number of sectors. So it's not 5 assessments, but 35 assessments. Let me go to your issue relating to testing of other areas. When there's an assessment, and maybe let me say the following: the investigations that we conduct across a number of areas. So they're not only confined to security compromises, but what we do is that when there's been an assessment, one of the things that we look at is under condition number 7. We look at quite a number of things, and one of the things that we would look at would be also standards within a particular industry. When we dealt with the Lancet Laboratories assessment, just to give you an example, we looked at the standards that had been set by the regulatory body, the Health Professions Council. We also look at the ISO standards and whatever. So you talk about best practices, and we do that. We look at best practices across a number of industries when we unpack the condition number 7. So that possibly would answer you. Maybe something that I omitted to mention is that as one of our priorities, we are in the process of putting together a guidance note on PIA. We are mindful of the fact that when we go out and we assess responsible parties, one of the things that we pick up is that there isn't a common understanding with regard to the compliance framework. And I think the PIA guidance note that we are going to put together will assist us with regard to addressing the question that you've raised, and it's in our AOP for this for the coming financial year. So that would address the question that you are raising. There was a question from Mr. Dickens relating to telephones. Mr. Dickens, I'm sure we are also as eager as what you are saying, but we are emphatic in our position that telephones falls within the definition of electronic communication. So once the matter has been processed by the enforcement committee and by the members, we'll have more clarity with regard to that. The code, submission of the code. The regulator has been operating. The fact that we have not been physically at the building does not mean that, and I'm sure you would have picked up that there are a number of decisions that have been made, even though we are not physically on at the premises. So feel free to submit your code of conduct, and we will process the code of conduct. And maybe just to say this, we will be going back physically to the office on the 16th of March. So that I'm sure that would assist you, but you don't have to hold on to the code. If you are ready with the code, you can submit the code of conduct. And then there's an issue relating to paper compliance. Our responsibility as a regulator is to ensure that responsible parties comply with our legislation. Now, you're correct. Some of the responsible parties also only comply on paper. And with the resources that we have, it's sometimes difficult for us to go to each and every responsible party and say, but let's see how you're complying. You know, it's like the police going to every person and trying to see whether those people are not contravening the law. We are bound by the resources that we have, but the monitoring exercise that I've spoken about will go a long way also in assisting us to pick up whether there isn't just compliance on paper compliance as you call it, or whether there's real compliance with the provisions of POPIA. I don't know whether there's any question that I've missed. If I have, maybe the members, the CEO and the members can come in and respond to the questions.
Advocate Strom, Yeah, acknowledge. Can we bring the mic here and then the CEO? We are still just responding to the first set of questions.
Thank you, Program Director. I just want CEO to add on what Mr. Ndlovu is saying. We don't have to reinvent the wheel. If you know the Compliance Institute principles, which you call the KISA Institute, Compliance Institute of South Africa, most organizations like banks have already have a, what you call a regulatory universe, meaning it's all those acts that the bank needs or an organization needs to comply with. Then POPIA or PIA will be one of the legislation that you will put in your regulatory universe, and also including the principles of King 4. So the best practice in terms of compliance management as a general principle in South Africa, the principles are already there and are embedded, and the principles are in the Compliance Institute of South Africa. So I think his point, he was trying to say most organizations, like I'm saying insurance, banks, they already have that. It's for you just to put POPIA as an act and sort of put risk management principles and compliance principles in there. You don't have to only rely on our peer to say you're doing a compliance, or this is our framework. There's principles in terms of compliance which are recognized in South Africa. So institutions like that are already having those regulatory universe don't have to go back and reinvent the wheel. They just have to put POPIA as one of the law that they need to comply with as an organization. I think that was his point in terms of best practice. It's already there. Thank you.
Okay, CEO.
Thank you very much. Just to respond to, perhaps to go back to what I said about vision, and I think maybe it might have been misunderstood, because I was just saying that the regulator wants to be an organization, it envisions to be an organization that is part of the world. I didn't mean that local best practice is ignored. I think I want to make that point clear. It's not the point I was making. But we have what you call a compliance universe that we've developed and are approved in the regulator, which guides us on a whole lot of pieces of legislation and everything that we need to comply with. But we have not stopped there. We're going for best practice every year. For example, this year we invited people from the Risk Management Institute of South Africa to help us to uplift our enterprise risks to strategic risks. So if you look at our risk register for the current financial year, and you look at our the risks for the coming financial year, they're different. They were operational all the time. So the Risk Institute helped us to take them to strategic level. So I want to say we are utilizing best practice, but our vision is to be a world-class institution where we want to go, where we want to be. It's not that we ignore local best practice all the time. We will be having a workshop in May where we will be looking at payer within the organization. And we've invited someone from the private sector, those people who are doing it well, to assist us to do our internal one properly. So we are still utilizing best practice. So I think the 2 points, it's not about us copying everything that is overseas. It's us envisioning to go to be a world-class institution, but our journey will be through learning from people locally, and that's the point I was making. And I hope it's clarified. Thanks.
Thank you, CEO. I think we can take a second round of questions. There was a gentleman here. I'm not sure if you've changed your mind, but you have the floor.
Thank you. Thank you so much, Program Director. My name is Wynand and my surname is Gelnys. I'm representing also a regulator, the NHBRC. I am the legal officer for the NHBRC, and I'm going to start by saying thank you for the invite, because as a public entity, we are getting a lot of these questions on PIA, POPI as well as as well as the legislation that was explained by the relevant executive. Now, my question relates to both legislation, PAIA as well as POPI, and I believe the executives will be in a position to give clarity on these pieces of legislation. Now, if you read the legislation, it stands opposite against each other, meaning it has different purposes. And from our side, we do understand the reasons for these purposes of legislation. But the question comes now, how do you find a balance between these pieces of legislation? For example, the executive spoke about the enforcement committee, and he spoke about the fines, etc., etc. The question comes from, is there guidelines that comes from the decisions that is made by the enforcement committee, especially for public entities such as the NHBRC? Yes, we do get that we are getting guidelines from court cases. The executive mentioned that there's a court case with the Department of Education, etc., etc. But it's not to say that all the court cases will be reported firstly. And to summarize, is the Information Regulator is the custodian of these pieces of legislation. And how I see it as well is that legislation, it boils down to interpretation as well. And especially public entities rely on the custodians, such as the Information Regulator, to produce guidelines or to produce decisions that was made by this relevant committees in order to guide the information officers of these public entities. Thank you so much, Program Director.
Thank you very much, sir. There's two questions here in the middle.
Sanibonani.
So,
Good day, everyone. My name is Rachel. I'm from Pulelo Enterprise Pty and from Ambassadors in Disability. So I don't know, maybe I didn't hear very well. Is the CICP engaged? Because we have to be safe there. And again, I've heard Mr. Bukanyo saying there are complex complaints and there are simple complaints. And we have listed again the number of cases. So could you please give example of those cases, one in the simplest one and the complex one? And again, as a chairperson of Ambassadors in Disability, I've got a database of people living with disability with their information. I would like to know, small as I am, but how can I comply with the regulator to protect the information of those people? Thank you.
thank you very much. There was another hand there. Standard Bank.
Thank you. Thank you so much, Chair, for the opportunity. Advocate, you mentioned that there is a test case before the Enforcement Committee on telephones being defined as electronic communication. Do you propose that we wait for the completion of that process before we take our own policy positions on the issue? Thank you.
Thank you, Mr. Nkonzo. Any more questions? Okay, I think let's respond to the questions that have been posed so far. I think there was a clarity in terms of the simple and the complex complaints, but I don't think Advocate Buikanyo does mind. So we'll go through that again, Rachel. Thank you.
Thank you very much. And there are a few questions here. Maybe let me start off with the question from Vainant relating to the balance that we must strike between the two competing rights. These rights are they're different, but they are complementary of each other. So our challenge also as a regulator is to ensure that the access to information does not violate privacy rights. So they don't, people often say that they are contradictory of each other. They're actually not contradictory of each other. One involves the access to information when you request information. The other deals with instances where personal information that is provided has to be provided within the confines of POPIA. And we protect such personal information. So our work within POPIA, people always mistake this and say, well, POPIA means that the information should not be produced. POPIA does not in any way indicate that personal information should not be produced. But when it's produced, it has to be produced within the confines of our enabling legislation. I'm going to allow the members maybe to weigh in on this particular one. And then there's the issues, you raise issues relating to the guideline. POPIA is still very new, comparatively speaking. The matters that are coming before the enforcement committee, we don't have, one of the things that we always talk about is that we don't have enough jurisprudence insofar as the work that we are doing is concerned. So what we do is that we always look at other jurisdictions when we don't have enough jurisprudence. But there's an exercise that we have started, and this exercise is within our EduCom division, to look at all the matters that we've had within the regulator. The matters that have been determined by the enforcement committee, and just generally the assessments that have been conducted. And from this, we're going to put together a document that will assist also with regard to the question that you may be asking. But what we do is that in the event that, because POPIA having some of the gaps that it has, we also look at other jurisdictions when we have such challenges. There was a question on simple complaints and complex complaints. I made an example, madam, maybe you may have missed it, but and I said, if we get a complaint, for instance, where there was a failure on the part of a responsible party to update or to correct inaccurate personal information, that we would consider that as a simple complaint, because it would be easy for us to investigate that particular matter that we will be receiving. And a complex complaint would be one where we require full investigation. An example of that would be an instance where I've said just when I started that we received a referral from the Madlanga Commission. Now that referral warrants that we must go out and we must look for certain information, we must gather documents, we must go through certain documentation. But one of the other, maybe let me give you another example, not using this one, where we have a security compromise that is reported and we go in as part of an investigation. We are going to have, and we go in to investigate, sorry, not to assess. What we'll do is that from that, this would be a complex complaint, because what we are going to be doing is that we're going to then be dealing with this thing in under condition number 7, the complaint under condition number 7. It would warrant that we must look at the incident response plan of the responsible party, etc., and determine whether there were adequate security measures in place. So we will peruse those documents, analyze those documents, and produce a report. So it's a full investigation that requires also technical expertise. We'll usually bring in the CIO or Mr. Mazibu to assist us with such analysis of a complaint. So because it's a full investigation, that warrants that we look at quite a number of things. That would be a full investigation, as opposed to a simple complaint. The CIPC, have we engaged CIPC? Yes, madam, we have engaged CIPC. As part of the process is that when we go out and we assess, as part of the process and in line with the rules of natural justice, we'll always afford the responsible party an opportunity to to comment. So we will write to the CIPC, will say we are coming in for an assessment or for an investigation. So in this case, it was an investigation. So we notified CIPC of the investigation that we are going to embark on. And we sent through a Form 8. Form 8 is a form where we officially notify CIPC that we'll be coming in to investigate them and afford them the opportunity of commenting. So we have engaged CIPC, and in line with we can never investigate and not afford the other party an opportunity to comment on whatever findings and recommendations that you may have. Standard Bank, Mr. Nkonzo asked a question relating to whether they should wait for the test case. You know, Mr. Nkonzo, I was hoping that you would be the one that gives me the answer with regard to that, having been an employee of the regulator. But what we can say is that there are quite a number of direct marketing complaints that are in the pipeline, and we are sending one as a test case to the enforcement. We have sent one to the enforcement committee, and based on that decision, and we know, and I can say this to you, Mr. Dickens, our insurance has already said to us, whatever decision that will be taken, if it's not favorable to them, you know, they will litigate. So we have, I think it suffices to say that we stand firm in our decision that telephones fall within the definition of electronic communication, and the litigation, we'll wait for the litigation at the right time. So, Mr. Gonzo, it's not an easy answer. There are other organizations that have started to comply with this, and that have started to take telephones as falling within the definition of electronic communication, that have done that proactively, and I'll leave it at that.
Thank you very much. I just wanted to add on to what Advocate Bikanyo has said. I want to stand up and respond to the question that Vane had asked. You know, you asked a question that I had a discussion with the CEO just last week about our jurisprudence, because now we are having quite a number of decisions that come out of the enforcement committee. So we need to ensure that we analyze them for jurisprudence purposes, so that when the enforcement committee sits, we should not take contradictory decisions. We must be bound by the jurisprudence that we have produced through the enforcement committee and use it in addition to the jurisprudence that comes out of the courts. So I think it's something that we were just talking about last week. Now, on the balance between privacy and access to information, maybe to be practical, if you look at the protection of personal information, in fact, let me start with PAIA. PAIA has grounds for refusal or exemptions. For instance, if you request information through PAIA, using PAIA, PAIA will say, if the information that you are requesting, affects the personal information of the person whose information that you are requesting, then that has to be taken into consideration, because personal information of a third party, it's an exemption in PAIA, unless you justify why that exemption cannot apply. So that's where the balance comes. When you go to POPIA on the other side, it will tell you the exclusions. One of the exclusions is processing of personal information by journalists. They say it's for journalistic purposes. So if newspapers, for instance, can publish personal information about me, if they can prove that publication of that personal information is in the public interest and that it's necessary to promote freedom of expression and access to information. You would recall a number of years ago, and that predated POPIA and PAIA. There was health information that was published of a very high-ranking cabinet minister. And there was a whole issue about whether newspapers can publish that kind of information because it was health information. And that's why POPIA comes into effect. It says to keep that balance. The newspapers can process personal information because processing of personal information for journalistic purposes, it's excluded from POPIA so that we ensure that we don't hide information, like that, especially if it's personal information of high profile people, and that information is necessary to promote public interest and also access to information and free flow. So the balance is there, and that is why we are a model, the South African Information Regulator, because it's very few countries in the world that have one regulator being responsible for both access and privacy. You find that in most countries, there's a commission, Data Protection Commission, or there's an Access to Information Commission. And if they are like that, then you are unable to do that balance. So with us, because we are responsible for both, when we look at complaints, we are able to cross-reference like that. I thought I should add.
Thank you, Chair. I know there's still a lot of questions, but can I propose that we defer those questions to during the lunch session so that we can proceed with PAIA? Due to time constraints, I'm going to request that we take a presentation from the PAIA executive. And then after that, after questions and answers, we will then have tea. Is that in order? Are you ready, Mr.? The PAIA executive is not ready. Okay, can I then change and request that we take a break because he seems to be a bit nervous. Let's take a break. 15 minutes break, please, 15 minutes.
Mobilization membership. The turnout is actually good. I thought I didn't think they would come. Yeah, I was also worried. Do you think how do you respond when someone says, okay? The thing is, it's different. Okay is Tsogo's language. In my language, when you say okay, it means where are you? Yeah. So, but when the person says okay, it's how are you? And as in like how are you? With us in Sepedi, we say lekai. Lekai or Ujwang. How are you? Lekai, Ujwang. In Tuana, okay is how are you? So if someone comes to say and says okay, if someone comes to you who's baby sounds like this, so I'm good, how are you? In my language, someone says Nikai Urerogona Ralina. Ralina. I'm good, how are you? Jen is it? You're going to get it. You're gonna get it. Are you lost? Because we're still bonding. I'm joking. I'm joking. Just pulling in. Pero, Wahala. What are you gonna write? It's not easy. Let's see. And it's like, what he made sure he elaborated. Chair. Like, could valid comment. You didn't complain. Some somehow tried and then they were like, just to be fair, they were like, but other people are coming too. And they didn't take the shot. If it was not
I'm going to request the colleagues from the foyer to just request the rest of the colleagues that are still having tea to come back. Mr. Mulaba, where is your team? Can they assist us to just call them back? Okay. All right, without wasting any more time, we are going to have a presentation by the executive of promotion of access to information, PAIA, Mr. Mugelani Dimba. Mr. Dimba, you have the floor. A round of applause for Mr. Dimba.
No, I was going to ask it for myself, CFO, if I didn't get it. It's still morning, right? Good morning, everybody. I'm going to try that again. You've just had coffee and tea. You should have energy. Good morning, everybody. Thank you. Let me start by declaring to Ukajeni that this is his lucky day. Because in the audience, there's somebody who not only knows Nsuze, but comes from there. And that is me. So, for some of you, let me explain how this works. If Nsuze was Sandton, Etalaneni, where I come from, is like Rosebank. So there's something in the waters of Nsuze that produces people like Kajeni and myself. Because the village in Suze is named after the river, and it's the river that crosses through all of those villages from Insuze to Etalaneni to Kwanongamlane to Kwazundi and all of those places. So that's our hood, Kajeni. No, thank you, everybody. Mine is to present the priorities of the PAIA division for the forthcoming financial year. I hope that I'll be able to move the presentation forward. So let me start off with the structure of the division that I represent. We have two main subdivisions. The one subdivision is compliance and monitoring. We do have a senior manager responsible for that. I will say a bit more about what this division does. We also have a complaints and investigations subdivision within the PAIA division. So it's pretty much similar to the POPIA structure that you heard from Advocate Buiganyo about earlier. I must say that I do know that some of you do get confused sometimes. You think the information regulator is the POPIA regulator. No, it's not the POPIA regulator. It's the information regulator. We are the other half to this scale. In fact, it is because of problems with PAIA that the information regulator was established, because it was established to fix certain challenges that were observed in terms of PAIA, particularly at the time when the regulator did not exist. People had to basically go to court to seek redress for instances where they were not happy with the decision of information officers. And that reliance on the court system meant that a number of South Africans were then excluded from fully exercising their right of access to information as a result of not having the resources needed to bring matters before court. This is why then the information regulator was created to make available to the public an easily accessible, specialist and speedy mechanism for dealing with complaints by members of the public. So we are quite happy as the PAIA division that we gave you this wonderful gift that is the information regulator. So that is how we are structured. But maybe just to give a bit more detail regarding what it is that we do. We are responsible for ensuring effective promotion, protection, and implementation of our constitutional right of access to information. Remember, PAIA as a legislation flows directly from the constitutional right of access to information as provided for in Section 32. That right says everyone has a right of access to information held by the state, and any information, sorry, and any information held by any other person so far as that information is needed for the protection or exercise of another right. So that is what we do. We are here to ensure that what is provided in the Constitution does become reality by monitoring what information holders do, by promoting the usage of the right, and also advancing the protection of the right itself. Those two subdivisions, starting with the complaints and investigations, we receive and investigate complaints on refusal of access to information. So if somebody has made a request for information and they've been refused that access to that information, they file a complaint with us, and we are required, in terms of legislation, to investigate that complaint. We facilitate access to records through mediation and conciliation. A number of the complaints that we receive, the majority of them, are resolved through mediation and conciliation. In the current financial year, we're sitting at around 500 or so complaints that have come through to the Information Regulator. Almost 80% of those complaints will be resolved through conciliation and mediation. We liaise with the complainants as well as the bodies against whom the complaints have been lodged, and we draft and issue investigation reports that are sent to the Enforcement Committee for a decision by the Information Regulator. So in a nutshell, that's what the Complaints and Investigations Subdivision is responsible for and what we do. We also have the Compliance and Monitoring Subdivision, which conducts compliance assessments. On our own initiative as the Information Regulator, we run these assessments to test to what extent the information holders are complying with the legislation. We also monitor the implementation of the recommendations that we make after we've conducted assessments. And also, we monitor the implementation of the enforcement notices, because once members of the regulators have issued an enforcement notice, which has the same force as a court order, there is a need to ensure that the information holder does indeed comply with the enforcement notice, and that is our responsibility. We are also required to receive what is called Section 32 reports on how institutions are implementing the legislation. I hope that our CIO, I don't know if Mr. Luyaba prepared some stats and slides to show how you are all doing in Mpumalanga in terms of submitting Section 32 reports. If Mr. Luyaba hasn't done that yet, I will take some time to quickly put together this and also do my own bit of naming and shaming. In terms of this requirement, the performance is really not good, I must admit. This requirement of reporting to us in terms of Section 32 is often honored in breach and not in compliance, particularly at municipal levels. We find that municipalities, both district, local, and metropolitan, well, metropolitans are doing much better. I should be fair to them. But local municipalities and district municipalities largely fail to comply with the requirement to report to the Information Regulator in terms of Section 32. So we are responsible for checking that as well. Just in terms of the milestones for the financial year that is coming to an end, we have conducted and are still conducting assessments in a number of different sectors. For the current financial year, we had a target of 80 assessments that we have to do across a number of sectors, including municipalities, Schedule 3A entities in terms of the PFMA, and we are currently busy assessing real estate agencies with their compliance with the access to information and data protection laws. So we're almost very close to reaching the target of 80. So far, we have conducted 48 assessments upon request because the legislation allows anyone to come to the regulator and say, I want you to assess that entity for their compliance with PAIA. So far, we've done about 48 of those. On the investigation side, like I said, the figure is around 500. We're still working out the final total for the financial year that's about to come to an end. But of those, as I said, the majority get resolved at the level of conciliation and mediation. And we have finalized 98 complaints that have come through to us. These are those where there is no agreement following mediation attempts or conciliation attempts. So we've done about 98 of those so far. And we have referred 7 of those to the enforcement committee. In terms of the simple complaints, so far we have about 47. Those are done, they are dusted, and there is no further work that is required. And I don't need to go into the differences between the complex complaints and the simple complaints because Advocate Buikanyo gave us an input on that. I must say that thinking broadly in terms of the casework, some of the work of the division has been very impactful, like talking about milestones. And it's something that a lot of our counterparts throughout the world envy us about. And I think it's a credit to the chairperson, the members, and the CEO, because we get into these platforms where they say, we heard that you ordered your receiver of revenue to disclose the tax records of a former president. That will never happen in our country. But that is something that we can claim because we take our obligations seriously, which require us to act without fear, favor, or prejudice. And it's one of the cases that we are quite proud of, the case involving the disclosure of those tax records by SARS. Another matter that we are quite proud of because it really shows how bold and how clear we are in terms of fulfillment of our constitutional mandate is a matter involving the State Security Agency and expenditure records by State Security Agency. We ordered SSA to disclose the information that they tried to deny a journalist from accessing. Again, if we can go for SSA, who are you in your little corner to think you can ignore us? Please do not ignore us, because unlike in POPIA, where there is likely to be a fine for lack of compliance, in PAIA we don't have a regime of fines. We only have the ability to file a formal criminal charge against you or against the information officer if you fail to comply with our decisions in terms of PAIA. So please, when we issue enforcement notices, please do comply, because failure to comply will make you liable for criminal action, criminal charges to be preferred against you. It is that serious. There are a few others, such as the Road Traffic Management Corporation. Again, here the requester wanted to get access to information about how RTMC determines the fees that they levy for all sorts of traffic fines and things like that. Again, RTMC did not comply, and we've had to file criminal charges against the information officer. So we're quite proud of this because it really shows the muscle that the regulator has to ensure and enforce compliance with our legislation. We are currently investigating the multinational big tech companies, Google. We've heard about WhatsApp. We are looking at Google. We're looking at YouTube. We're looking at TikTok. I think there has been an agreement of sorts with TikTok. All of this was about how these platforms are implementing their own risk mitigation measures during the times of elections. These companies did not want to cooperate with the requesters on the information that was requested, and so a complaint came to us. And we are now tackling those big tech companies through the abilities that we have in the PAIA part of the work of the Information Regulator. So what are we planning to do for the forthcoming financial year? We have altogether, I think about six output indicators for the forthcoming financial year. Firstly, we want to be able to investigate and complete simple complaints, and the target there is 70%. For complex complaints, the target is 50% for the forthcoming financial year. We're also intending to facilitate the access to records through settlements and conciliation at the level of 70% of all complaints that we receive. So that's on the investigations side. On the compliance and monitoring side, we have a target of 50 public and private bodies that we want to assess for their compliance with the provisions of PAIA. And we have a target of 50% of assessments that are conducted upon request. We are planning to monitor all the entities that would have assessed. So 100% is a target for the forthcoming financial year, where we say all of those entities we have assessed before, we are going to track them for compliance with the recommendations following those assessments. And then lastly, we're going to publish an annual assessment report that will give a picture of what we are finding through those assessments that we are conducting. So those are the key indicators for the forthcoming financial year. I'm going to, I think I'm running out of time. I'm going to skip the slide. I want to talk more about the challenges, and I won't cover the same challenges that Advocate Buikanyo addressed, issues of financial resources. We have a very, very small team. All of those numbers that I mentioned previously, they are being dealt with by 5 individuals in the compliance section and 5 individuals in the complaint section. So I won't get into that. I think it has been expressed in detail. We are starting to experience challenges with some of our complainants that want speedy resolution to their matters. It's a challenge. I'm not saying it's a bad thing. It's a good thing. But it's just that given the resources that we have, we are struggling to be able to provide speedy resolution to the complaints that we were receiving. So there's a fair amount of time being spent explaining some of our processes to the complainants. And for those that come from public and private institutions that are responsible for compliance, please, please, please drop all of those old forms that you have in your manuals and in your websites. A lot of the institutions still have their Form A, Form B, and Form C from long time ago. Those forms are no longer used, and they cause problems for us when we have to deal with complaints, because the legislation requires that the complaint must be based on a properly lodged request for information. So a lot of the requesters get these forms from your institutions. These forms are old. They are no longer to be used. Again, the manuals are still very much outdated. We still find manuals that were put together in 2004, 2005. They are still on your websites. Please, those of you that are either deputy information officers or you support deputy information officers, please embark on a process of updating your manuals. Now, Chair and CEO and the members, this is where I have to express frustration. The chairperson indicated that I am in an acting capacity in this role. I've only been in this role for 7 weeks. In the 7 weeks, I've processed 49 matters in the 7 weeks. And when I say process, I mean I have approved pre-investigation reports. I have approved summons being issued. I've approved or actually finalized closing reports. So it cuts across those 49 matters that have come before my desk. Of the 49, 95% of them are a complaint as a result of, one, the information officer is claiming that the information does not exist, the record does not exist, or the record cannot be found. Number two, the information officer is claiming oh, the information officer doesn't respond at all, which is called a deemed refusal. So 95% of the matters I've dealt with, either the information officer has not responded to the request, or the information officer says the record does not exist. It's provided for in PAIA, but let me show you the difficulty with this. If the record, it's an example, if the record requested is a building application for a structure that was put between two plots, they go to the municipality and they say, can I see the building application? Can I see the approval for the construction of this building? And the response comes and says, the record does not exist. How was that structure built? Okay, fine. So the structure was built. That means then the bylaws are not being enforced if there can be an illegal structure built and nothing happens. So it says to me there are two things here. Either babulela, sorry, I nearly said something. Hababuleli niti. I nearly put it the other way around. It's either they are not being frank with the requester or they are failing to enforce the bylaws. So it cannot be. Let me give you another example. And we are now struggling with the hospitals. People go and make requests for information for their health records. And the response is the record does not exist. But the person knows that they were in this hospital. So how can the record not exist? If the record does not exist, it means there's violation of POPIA because the health file has special personal information and it has been lost. So POPIA has been violated. So now what we need to do, I just wanted to say to my leadership that we are, as the division, we are not going to be able to simply close those matters. But what we now have to do is to refer those matters to SALGA, refer those matters to the public protector, refer those matters to all other regulatory authorities that are overseeing a particular area of practice. The days when an information officer says the record does not exist and it's the end of the story are long gone. Unfortunately, the CEO chose a human rights activist to act in this role, and zizojika izinto. Thank you.
Thank you very much, Mr. Dimba. Now we are opening the floor for the questions. I think my opening remarks did say that there is a liability that comes with refusal of allowing persons to access information. So that liability is what we need to avoid. So the floor is open for questions. There is a gentleman there at the back.
Okay, thank you. Wanani again from the Consumer Goods and Services Ombud. I just wanted to find out, the current legislation, do you think it addresses the challenges posed by artificial intelligence? Considering that AI is also making decisions, would it then be a defense to say that the decisions made by artificial intelligence technology was incorrect?
Right, any more questions? The questions that side on my far left, which would be your far right, Ms. Ngobeni. There. Oh, yes.
Thank you, Program Director. I'm Abongile Makai from Department of Public Works, Roads and Transport. Firstly, I welcome the presentation that was done by Mr. Ndimba.
Mr. Dimba.
Dimba, thank you. While Mr. Dimba was presenting, I was busy ticking some boxes for my department. But my question is based on submission of Section 32 report. When we conduct the submission, we will receive, for instance, 10 requests. In those 10 requests, we refuse maybe 2. And then we engage with the requester for maybe another 2. We engage in terms of maybe they must give clarity or give us more information in relation with the information they're requesting. Then at a later stage, they decide not to respond on our correspondences. Then we grant maybe 3. So we also receive maybe 2 requests, which those one fall under section 22 that need to be transferred for the relevant entity. Under section 20, sorry, that need to be transferred to the relevant entity. So when we conduct the reporting, sometimes we find the challenge whereby we will say we received this 10, we granted 3, we refused 2, and there's also those pending, which is the requester never came back, and we transferred 2. On the portal, there's no space whereby we will maybe make a comment in terms of why our number doesn't correspond with the number of requests received. I want to check on that. How can we deal with such situation? Thank you.
Thank you very much. There is a gentleman just behind you. Okay, yeah, it's fine. You can
Thank
go
you,
ahead.
Chair. I also want to welcome the presentation by Mr. Timba. My name is Chawlane Mkonta. I'm from the Office of the Premier here in Mpumalanga. I want to check if the information that we are requesting maybe is deemed to be classified, or you request the information and then when you request it, it's marked classified. So what do you do? What is BIA saying in that situation? Thank you.
Good morning, colleagues. Igama uJabulani wakasukwini Sibongo. I'm from the Mpumalanga Provincial Archives. I would just like to ask, Mr. Dimba spoke about updating of the manuals by institutions. Is there maybe an updated prototype that can be used? Because one of the duties that we do is conduct records management inspections in institutions, and we advise them to ensure that these legislations are drafted. So I just want to ask, is there an updated manual that they can use to do that? Thank you.
Okay, there's a gentleman at the back.
Thank you. It's Stephen Ndlovu from Gajani Advisory. I just wanted to share some comments off the back of what was said regarding records that have gone missing. And I want to comment from a public sector point of view. There's actually 3 layers. In my experience, there's 3 layers. There's, generally speaking, when you go to the public sector, there is a records management policy. It's there. But when you engage stakeholders in the organization, they'll tell you that, look, we've never heard of the policy, we've never read the policy. In other words, it's adequate, but it's ineffective because there's been no training and workshopping of the policy. And I think that's contributing to some of the friction that you see, lost records, etc. And then the second layer is records, again in the public sector, where records are generally kept indefinitely. So they're kept in some storeroom, they're kept there in a box, etc., in a steel cupboard, and so on, and that happens indefinitely. Obviously, that's a contravention of Section 14 of POPIA, and we've dealt with organizations where there was a fire in the building and the documents were destroyed and there was no backup of the documents. That's one iteration. There's also been situations where documents just go missing. But the point is, if documents are kept indefinitely in contravention of Section 14, then anything can happen. And then the third layer is where organizations just send documents off-site to various service providers. Again, that happens indefinitely. And a lot of the time, because of the vacuum of records management in the organization, no records manager, etc., in terms of the National Archives Act, again, that contributes to a situation where you can't account for the document because ultimately there isn't a warm body that's been appointed to make sure that the records management process and the policy are implemented and are effective. So I just wanted to make those few points. Thank you.
Thank you very much. Before we proceed with the round of questions, can I request that we respond to the first round? Mr. Timba?
Thank you all, and thank you for those very good questions and comments that have been made. I'll start with the first one on the issue of AI. This is when I have to admit that no, the legislation as it is right now is no longer fit for purpose, and I'm quoting the chairperson of the regulator. A lot has happened since PAIA was enacted. PAIA was enacted in 2000, and it was enacted on the basis of accessing a written record or a record on a memory stick or a record on some tape or CD-ROM. We experience information differently these days. We access information differently. We receive it differently. And so what we have in this legislation is unfortunately quite outdated in terms of the modalities for accessing information. Never mind the impact of AI on the process of accessing information and decisions that are made by officials in response to requests for access to information. So to this extent, there is a project underway at the regulator to create or to propose amendments to the legislation so that it is fit for purpose. A lot of the civil society organizations that we engage with are really focused on the issue of not only accessing information, but accessing data, which lies at the core of the artificial intelligence revolution. So watch the space. We will be coming back to all of you as stakeholders to say these are our proposals for bringing PAIA to the modern era, because we are quite aware that PAIA currently is not fit for purpose. Okay, yeah. Now let me come to Mr. Makai's comments regarding submission of Section 32 to reports. I think we can engage with the CIO. I don't know what is possible, but I think we can engage on that point to see if we can make a field available for the deputy information officers and information officers to add commentary just in case the numbers don't tally the numbers that they are submitting. I'm sure CIO will be open to that. From the Office of the Premier, what happens if you get a request for information that is classified? I will try not to smile too much. If you receive a request for a record and the record is stamped classified or top secret or confidential or whatever else, that stamp does not mean anything unless the reasons for protecting that information are established in Chapter 4 of PAIA. So those that classify documents, they need to ensure that their classification decisions they are based on Chapter 4 exemptions in PAIA. And I think PAIA provides a fairly comprehensive regime of exceptions or exemptions, things such as national security, things such as commercial interests of public entities, things such as information about a private, a third party or a private person. There are many, many exemptions that can enable proper classification. The trouble starts when you classify something that PAIA says should not be prevented from disclosure. So let me just give you an example. Information related to the public functions of a public official. Who is the official responsible here? What is their salary scale? Who do they report to? Those are standard items that should be made automatically available to the public. But if in your classification decision you say this is secret, you're going to run into trouble with PAIA. So we always advise the information holders, especially those that are responsible for classification and declassification, to really inform themselves about the grounds for refusal in PAIA, because you will struggle to justify your classification decision if it's not based on the reasons for refusal or the grounds for refusal in PAIA. I would say that one other thing we advise people to do is that if you find that you have classified something that should not have been classified, you need to go through the normal process of declassification. Remember that you still have that obligation to declassify the record and then release it to the requester. But we can engage further, say over lunch, if there's still a follow-up question on that. On the issue of the manuals that are outdated, yes, we do have a lot of materials on our website. Please have a look at some of the guidelines that we have produced on compilation of Section 14 manuals if it's a public body. We also have a look at the PAIA guide that we issue as the information regulator. One of the activities that we're going to be carrying out in the forthcoming financial year is to update that guide. But all of that advice is available. I think the colleagues from EduCom, you can reach out to them. They can point out where those materials can be found on the website. Thank you, Program Director. I think I've covered. Oh, yes, the chairperson wants to come in.
Yeah, just to add to what Mr. Dimba has said, I think what sets us apart from other institutions like ours is that we are I think we are the only one in the world where PAIA applies to both private and public bodies. Because in other parts of the world, people can only request information held by a public body, being a government department. And everybody gets surprised when we attend international conferences to say that we South Africans can ask for information from any private body for as long as they can prove that they need that information to exercise or protect a right. That is why we have had PAIA requests from the likes of Google, from the likes of Meta, from TikTok. In other parts of the world, that doesn't happen. That's why the phrase fit for purpose, because I said, look, as long as you have in the world legislations that apply to publicly held information only, those legislations in this digital age are not fit for purpose, because most valuable information is held, and data is held by social media companies and digital platforms. So I thought I should add. On the issue of declassification and classification and so on, in addition to what Mr. Dimba has said, if you want to rely on the exemption that you cannot disclose the information because it will compromise national security, you can't just end there. Because once you say, if you just quote the act and say, well, we cannot disclose because disclosure will compromise national security, we're going to order that information should be disclosed, because you have to convince us. You have to say why you say so, how that information will compromise national security. If you don't say so, we order release, as in the SSA case that Mr. Dimba referred to, because SSA simply said to us, no, this information cannot be released because it will compromise the security, without saying how. So because of that, we said information should be released, and the information was released, actually. And on the private, that we also, our act also applies to private bodies. It's not all, in fact, it doesn't exist that a body like ours can order the Johannesburg Stock Exchange to release information, because we had a complaint on insider trading, and somebody wanted information on how those prices, they were determined, the share price and so on. And they said they couldn't. We ordered JSC to release that information because our act applies to both private and public bodies. So as Mr. Dimba has said, if we can go, for JSE, if you are just a small person like me sitting in a corner, I mean, if we come to you, you are dead. So it's better if you comply.
Thank you very much, Chairperson. Can I request that any additional questions to PAIA maybe be deferred towards lunch, so that we can try to finish the program on time? Without further ado, thank you very much, Mr. Timba. A round of applause. Now, I am going to call Miss Zondi, who is the acting executive EDUCOM. She is going to take us through the education and communication presentation. Miss Kakash, Makakash.
Thank you, Chairperson of the session, and good day, everyone. Okay, it's still good morning-ish. Let's take it down a notch now. No enforcements and all of those, but we are going to be presenting on the education and communication division. But before we start that, I'm going to ask your indulgence, Chairperson, that I would like to do just a short exercise, because as education and communication, we really want to know your lived experiences in understanding us, accessing us, getting information from the Information Regulator. As I've been introduced, I am Nomzamo Zondi, and I am the acting executive for education and communication, basically making sure that you are aware of our programs, our policies, developments, and events. And I can proudly say that by the show of that the room is full, that means you do access our information and know about our events. But I'd still like to just engage a bit just to check the levels of those that know about us and our programs. And also those that are online. Hello, which camera do I look at? That one. You are most welcome, and thank you for participating and staying with us. And I'll also invite you to just also participate in this short exercise. I would like to request maybe the media production manager to assist me. And as you can see, if you do have phones and able to participate, do we have phones? Do we? Yes? No? Of course you have phones. So please, can I just invite you to just scan the QR code quickly. If you can't, I'll ask you to just go to menti.com, and then you'll see where it says vote, and then you can enter that code at the bottom. I think even people online can also do so. So please, can you just indulge me for a second, where we would like to find out first if do you feel well informed about the Information Regulator's programs, developments, and events? Let's see if we are doing an okay job, or do we need to actually amplify our communication efforts, training efforts, public awareness efforts? So I'm gonna give you a few seconds. Let me see. Eish, that too no is worrying, but it's okay. It's the true reflection. It's good to put a mirror up against our work. All right, so we will close that off, and I do see that we have about 24 people who are well informed about the Information Regulator and our work and our developments and events. I must say that I am a bit concerned with the 14 that do not, but nonetheless, it then tells us that we need to do better. If we can then move to our next question. I want to just check, how and where do you get information about the Information Regulator? Do you get information through our stakeholder engagements, our social media platforms, our training sessions, maybe our websites, or you do not receive any information about us? So I would like to know, so that we know what we need to do better, where we need to still do the good job we do on these platforms. I see they are coming in. It looks like social media is leading at this point. There are people that don't receive any information. Our website, training, stakeholder engagement, but seems like most people do rely on our digital platforms for information. Thank you for that. The 10 people again, we will like to then know in the next question, how is it that you'd like to receive the information? So I see that you do rely a lot on our social media platforms. We'll make sure that we do still develop content that is reliable and informative on our social media platforms, and continue with our stakeholder engagement sessions and improve on the accessibility of our website as well. We can move to the last one, please, which then I would like to just know, how would you like to actually receive information about the Information Regulator, our work and so forth? Maybe if you just quickly type something in. No? Yes? Okay, so I guess then what we had indicated is sufficient. Okay, let's see. Email, our website, okay, radio, happy with the current state. Thank you for that. Media communication, we're seeing newsletters. Okay, thank you so much. And we do see that you also would like to see us communicate better through our website, via email, TV, radio, and emails. Okay, thank you so much for participating. Please do give yourself a round of applause. We don't take that session for granted. It does really equip us, as well as the Education and Communication Division, to be able to enhance and ensure that we are really meeting you and reaching you where you are. So I will start my presentation at this point. Oh, I have a clicker. Oh my. Yeah, and I'm waiting for it to move. So, and what I want to emphasize as well is that when we do engage in our communication efforts, we do engage with you as a members of the public and stakeholders to understand how would you like to receive information. One of our very key projects as education and communication is that we do public opinion surveys so that we can gather your awareness and knowledge of the regulator and what are the issues that maybe hinder you to be able to access information or know about us. So in summary, when we did a public opinion survey in 2023, amongst many things, we just did a search, or we did inquire about the general awareness by the members of the public and stakeholders about our existence, but we also did a public opinion survey that was also looking at the issues of the knowledge of the regulator's function. And what we found is that significantly under the awareness of the regulator's existence, significantly only 30% of the public indicated that they've either heard a lot or a bit about the regulator, which is not enough, and approximately about 70% knew nothing about the existence of the information regulator, which again is still a worrying factor for us, which is why you find we have such robust engagements and we crisscross the country just to make members of the community aware of the information regulator. But we also noticed that awareness of the regulator was mostly found to be higher on the amongst racial minorities or tertiary educated person, and also employed persons or citizens that have access to digital platforms and so forth. And the knowledge about the regulator's function, I think by virtue of us having a lot of people not aware of our existence, then they wouldn't have knowledge of our functions and so forth. And similarly, people that have knowledge about our functions are those that are tertiary educated and employed, or have better financial standings and access to digital platforms and so forth. Now that tells us as education and communication where we need to improve our efforts. Kumele ukuthi siye emakhaya, siye emalokishini and really educate abantu bomphakathi about amalungelo abo, and ukuthi kukhona lesi sigungu esiyi-information regulator to protect your human rights as so far as it relates to privacy and the right of access to information. So, who is the team behind education and communication, so that you also understand that the efforts we're trying to put through, these are the people that are, or the units that we have that deals with education and communication. We do have an executive office that has administrative support, but these are the key functions that we have under education and communication, which one is stakeholder engagement. Unfortunately, we do not have a senior manager in that division, but we do have a senior stakeholder officer that coordinates stakeholder engagement with admin support. We also have policy analysis and research, where we have a leader, senior manager, policy analysis and research. We have a senior legal researcher, a researcher, research assistant, as well as administrative support. Then we also have education and public awareness. We have a senior manager in that subdivision, a manager for sector training, and a manager for public awareness and administrative support. And then the last subdivision of function that we have in our unit, in our division, is communication and media, which is also led by an acting senior manager, manager media production, a communication officer, and there's also administrative support in that unit. Now, what do we do as education and communication, and in line with the 4 functions that I've outlined? We do have a responsibility and an obligation. As you can see, I hope that those images do make sense. It's supposed to be a bridge. Does it look like a bridge? And a link, right? A chain. So that is just that states exactly what we do as the Education Communication Division. We are a bridge between the organization and the public to ensure that there's flow of information from the regulator to the public, from the public back into the regulator in terms of how we are perceived, what we need to do better, and so forth. And we also do create that link between the organization and the members of community. So we do, as CEO alluded to our values, as being responsive, accountable, transparent, and we have that responsibility to ensure that there is that link. So in terms of our communication and media function, we do communicate, coordinate media engagement relations, making sure that in the media we do present our priorities and our programs. We provide education by making public statements about the organization and any developments that may be in the organization. But obviously, we also have a responsibility that as much as we communicate with stakeholders, public and private bodies, we also ensure that we also robustly communicate with members of the public who need to exercise their rights. Then we do education and training. Here we develop and conduct educational programs where we do train information officers, deputy information officers of public and private bodies, NGOs, and so forth. And I must indicate that we do allow for an invitation for us to train, but we also do put out programs on our own initiative for training opportunities for you to be trained on POPIA and PAIA, so you're able to comply with the two pieces of legislation. In terms of stakeholder relations, our stakeholder relations management is both domestic and international. So we do coordinate cooperation in terms of national, international, on an international and national basis. We also coordinate consultation and receive reports from public and private bodies on issues of compliance or matters that they are grappling with, so that we are able to then respond in terms of those matters that may be brought to us. But in terms of policy and analysis and research, that is generally just the backbone of us, of governance, and us being able to develop policy positions, helping the organization to make informed decisions in line with our mandate as well. So we do prepare recommendations for development, improvement, modernization and reforms of our legislation, and we also then compile reports and any policy matters that are related to the protection of personal information. So yeah, we do a lot, right? I'm seeing that I may be overwhelming with that, but that is just me giving you a high-level view of what we do. So we do more. And then I'd like to just maybe go to into the issue of highlighting some of our milestones. I know I'm giving you a cocktail of pictures here. I hope you'll be able to follow with me. I wanted to give you a picture story of some of our milestones. So in terms of the us as an information regulator and as the education communication division, we want to create visibility, not just for people to see us and know us, but for us to educate and inform you so that you are able to exercise your rights, but also urging public and private bodies to comply with the legislation. So unfortunately, we are only based in Gauteng. We are only based in Gauteng, and I think CEO and Chair alluded to that fact. And however, we do have a flagship program that has been quite successful and appreciated by members of the public. And I want to say this on record, that I really do appreciate our chairperson and members and executives and CEO, because in other institutions, you don't really get commissioners or members and CEOs and executives always being present in every public engagement or awareness, and as well as stakeholder sessions. But they always there, they stay and they participate, and it's really appreciated even by the members of the community. So in the past few months, we've been to Free State, and we do target areas in the hinterlands, rural communities, disadvantaged communities, and we hardly do have our dikopanos in the city center. In fact, we don't ever have them in city centers, but we do take this dikopano, a gathering meeting with the community where they are. So we had one in Free State in Tabanchu, we had one in Uppington, Rasvater, we had another in Signal Hill in Northwest Mahikeng, we had another at the Delft community in the Western Cape Province at the city of Cape Town. But also another milestone that I want to touch on is our training programs and the fact that we do develop our own training manuals, which also talks to the quality of our training, as this information stems from the regulator itself, and that then also give that credit to the level of quality and credibility of our trainings, which again we get a high demand and on requests for training. Unfortunately, because we have one sector manager who trains, we're unable to sometimes respond to all requests. But it is a milestone for us to be able to develop our own training manual and conduct trainings from as the regulator. We also focus on empowering children on their rights, because they also felt like they were left out. So we don't only as adults have the right of access to information and the right to privacy, so does children. So our focus has been engaging with children, educating them about online harms, how to protect personal information, and so forth. And we have found that to be very, very delightful, and also kids are very knowledgeable in terms of even their rights and making comments and inputs in terms of how we can actually do better to ensure that they have right to privacy as well. And I think what is also a milestone for us is how we now coordinate our program stakeholder sessions. We could have been somewhere in Midrand or in city of Johannesburg or Pretoria, but we have now embarked on rotating in terms of our engagements. That's why we're in Emalahleni today. Tomorrow we could be in Hazy View, we could be in AM Sunduzi, in KZN. So we try to really, the fact that we are in Gauteng doesn't then stop us from really taking our programs to all other provinces. And also our milestone is the way we've tried to simplify Popia and Paya through our digital media content, which is why you found that most of you do appreciate accessing our information on our digital platform. So we have taken that approach to make our content engaging and easy to understand and interpret by simplifying Popia and Paya and sharing this on our platforms. But lastly, our international cooperation that we have, and we've signed multiple memorandums of understanding with our counterparts on the continent, so to strengthen our functions. I think what I just want to highlight in terms of what we want to do this year, we still want to continue to ensure that you are very informed, you are trained, you are able to exercise your rights, and these are just some of the key activities that we have. Of course, we have other key activities that are also contained in other plans, but these are the ones that we've planned for this year. Our key targets in terms of this year for training, we have education programs that we will conduct to promote the protection of personal information, and as well as promote access to information. And we're looking at hosting about 28 of those training sessions. Our other key target is looking at public awareness programs on the right of access to information and right to privacy, and we are conducting about 20 of those this year. And those programs, again, incorporate issues of public awareness, community dialogues, and engaging with different organized structures in the community. Our key target in terms of public opinion surveys, I did indicate to you and gave you just a highlight of what was some of the outcomes in 2023. We're hoping that picture will change, and which is why this year we're continuing with conducting public opinion surveys just to see between 2023 and to date whether our efforts to inform you have changed. We hope it will be a different picture, but again, these public opinion surveys are to assist us to improve the awareness levels of members of the community and stakeholders on Popia and Paya. Then our last target is for us to actually make inputs to propose legislations and policies of government that has impact on the protection of personal information. And this is one of the pieces of work that we do, where we do make inputs in terms of any legislation that is being either reviewed or any regulations. And we have started that work even a year or two ago, and we're still currently doing so. And we have done so by even making inputs this year on issues of the white paper on local government. We've made inputs in terms of impact and effect on Popia, to regulations on admission of learners to public schools, National Credit National Credit Act regulations, as well as the Children Amendment Bill, but that's just to name a few. So that is our last target, to continue to do so, because we feel that there should be inputs from the Protection of Personal Information Act that has effect or impact on other legislations. I think the issues in the part about our contribution as EduCom towards the strategic plan of the organization, I would say we are like the biggest cog in the wheel to move the regulator forward. And I say this because the impact statement of the organization, which is to ensure that all persons, everyone is empowered to exercise their right to privacy as it relates to protection of personal information or the right of access to information, really speaks to our function. Because truly, if you are not informed, if you are not aware, how will you comply? How will you exercise your rights? So that's why I say that I think as EduCom or Education and Communication, we are the biggest cog in that wheel to move. Not to say anything to you, Advocate Boikanyo and Mr. Dimba, but I thought I should just put it out there. And then our education and training programs really are to assist you to comply, because really if you do not comply, then the members of the public cannot exercise their rights. So it's important that we educate, we train, so that you improve your compliance level. So that is how we also then contribute largely to our strategic plans. And increasing public awareness is that we want to ensure that members of the public do exercise their rights. Now, here it comes to the challenges. We do have challenges as EduCom, as the Education and Communication Unit. As you would see that we do have a thin team, we do have big ideas. However, there are challenges that dribbles us or cripples us to be able to ensure that every single 60 million of us in South Africa are aware of the Information Regulator and the pieces of legislation and your rights. So we have insufficient public awareness materials. Materials is not just a booklet only or just a flyer. It can be many things. It can be developed information videos. It could be information that is in Braille. It could be sign language materials. So we really make sure that we reach everyone in the country. So we don't have sufficient public awareness materials. We have a high demand for training sessions, which is also a challenge, and we unfortunately cannot reach every request that you make. We also have information regulator imposters on our digital platforms, where you find that there are social media pages that are not of the information regulator. And in the age of mis and disinformation, it is a problem. And I would like to urge members of the public that we do ensure that we follow the correct pages that are verified, so that you do not get misinformed, or you are then swayed and told that this is POPIA when it's actually not. It's always best to verify and know that you are following the correct digital platforms from the information regulator. Stakeholder engagement, relations, the demand is also growing. We do try to cater for everyone. However, I should just put it out there that we do have constraints in terms of ensuring that we respond to all. Lack of resources to heighten communication awareness in an innovative manner. That costs money. It really does. And so for us to be able to be innovative, ensure you are greatly informed, we need to put innovative measures in place, ensure that whatever communication and awareness products we develop or programs we run, they are very inclusive and leaves no one behind. Now, I would like to invite you all, especially organizations, institutions. We are open to partner with organizations and institutions. We're currently working on a framework for partnerships with stakeholders, so we are able to be supported in terms of our initiatives to make members of the public aware, but public and private bodies also aware. Now we do seek sponsorships. We welcome those. My pockets are very empty right now. There's absolutely nothing. This is full transparency and disclosure, by the way. We do seek partnerships as well to ensure that we create these awareness programs, and we do drive communication and awareness around the right to privacy and right of access to information. And we do also invite collaborations. So that is just my plea and invitation to those that are in the room, those that are participating online, that we want to make sure that our education and communication is impactful. Public and private bodies are aware on how to comply, and members of the public are able to exercise their rights because they are informed. Thank you so much, Chairperson.
Wow, I like that. Kusho ukuthi igagu magagashi. Siyabonga kakhulu. So will open the session for questions and answers. I'm not sure if there's any questions in the room. There's a gentleman there.
Good afternoon. Is it afternoon already? Yeah, it is. Thank you, Ms. Zondi, for a comprehensive presentation. My name is Tebogo from Standard Bank. I attended the stakeholder engagement on gated communities, and today I'm here, and it appears though stakeholders are grappling with a balancing of rights between Popia and Paia. Do you think it's an opportunity maybe to create awareness on balancing of rights to capacitate stakeholders to be able to comply or consider and maybe see what needs to be considered when they are looking at the two pieces of legislation? Thank you.
Thank you. More questions? Okay, no, that's the only question that we have for now. Okay, there's more. Right, let's just take a few more.
All right. Greetings to everyone. My name is Nelly Makanya from Blue Dot Property Management. I am a managing director there. So my question is based almost similar to what the gentleman has just highlighted too. Being in the property industry, the biggest struggle we have is balancing the transparency of our clients and protecting the information that we handle. There's a lot of questions in that industry that have not been tackled. I hope someone from CSOS is here from the AMBITS so that we can get these questions and issues addressed in the industry, because our clients require a lot of transparency from us. If you are telling them that the scheme is owing a lot of money due to non-payment, they want to know how did we get there, how much is owed, who owes, and all of that, and yet we still have to protect this information. From my personal experience being in the industry for the number of years I've been, there is a lot of imbalance in the industry, and the industry is not regulated, and all these laws are coming in and we need to put them in place. And it puts us in a very disadvantaged positions as managing agents in the industry. So I'd also like to know what initiatives can we help with as managing agents in the industry with, you know, helping in terms of communication and awareness to the public, which it would be our clients, obviously. And secondly, are you working with the CSOS, which is to help regulate the industry when it comes to protecting personal information and also being able to disclose certain information, because there's a lot of information, including your footage from gate access and all types of information like that. So I'd really want to know, where is the industry being considered and what do we need to look out for in the industry? Thank you.
Okay, thank you for that question. I think I saw a hand somewhere here.
Thank you very much. Ms. Zondi, you spoke about training. Ujablani again from Mpumalanga Provincial Archives on compliance. So I would like to find out, as the Provincial Archives, we conduct awarenesses to public to let people know about the services of the Provincial Archives. Can we invite you to be part of us as and when we do the awareness campaigns, and can we also invite you to do training for our stakeholders in terms of compliance, meaning all the governmental bodies that we inspect? Thank you very much.
My lady, yeah, my apologies. I didn't realize there was another hand at the back. You have the floor.
Good morning. My name is Dr. Nell. I'm a director of Childline in Mpumalanga for the province. And we go from school to school to talk about children's rights and child protection and prevention of child abuse. And I see that you've got school programs that you are doing, Ms. Zondi. So I'm thinking, Possibly you've done it age appropriate on the level of the child so that they could understand, primary school, high school level. If we could collaborate, we've previously worked with the Film and Publications Board also on protection on all the social media platforms that there is for children and bullying and all of those things going on. We don't have funding to offer you, but we could work together, and I do think it will make a difference for children, because we see when they grow up as adults with good information, we have a healthy tomorrow. So thank you for the opportunity.
Thank you very much. That's a lovely offer, Dr. Nell. I think we would appreciate that a lot. So, colleagues from Educom, we are free to assist Ms. Zondi to respond to all the questions. Ms. Zondi, you have the floor.
I don't know whether I should still keep my pockets up or put them back in, because no one made an offer yet, but I will put them back because Charline, thank you for that. I will start with Tebogo. I think I'll try to couple it with, sorry, I didn't get your name, sis. The issue of the gates, well, thank you firstly for attending our sessions and being there in the last one that we held about a week or two ago. And we do note the issue, it comes across, in fact, we've noted in our issues list when we engage with stakeholders, the issue of balancing the right of access to information and right of privacy in conducting your business. And I can gladly say now that I think the manager stakeholder is here. This year, we are planning to have structured webinar stakeholder engagements which emanate from the issues that you are raising. In fact, so this is already a contribution for us to have a session that will focus on such issues that we can engage with you on. So I think the chair did highlight, and Mr. Dimba and advocate in terms of how practically can you balance those rights, but I'm noting that it's something that we probably have to plan for and have a webinar or a session where we can have further engagements on this, because there are practical examples of how to do it. I don't want to waste too much time, but there are simple things that we think are really complicated, but they are not. Redacting before you make sure that you respond to that right of access to information, and redacting the information so to ensure that there's a right to privacy of the person who their information will be on that document. So those are the things that we can share, but we do take note of that, and we will coordinate a session that will talk to those issues. In relation to the issue of engaging or collaborating with CSOS, yes, they are one of our stakeholders, and we have received a lot of inquiries and requests from property institutions or property or managing agents on the issues that they are grappling with as well. So like I indicated, that we do identify such issues that are raised, and we will definitely do consider that in our plans. We've had even codes of conduct from the property industries that have been sent to us. We've engaged with those submissions. We've had engagements with property agents as well. I mean, the session alone 2 weeks ago talking about gated accesses was looking at issues where the community, the sector was invited, and there was robust participation. But what you are raising about us collaborating with other institutions is very important, so that we are able to drive a united front where our mandates also intersect. So we are open to engaging. We do, in fact, invite other regulatory bodies and commission to our programs, so that we are able to speak in collaboration on issues that may impact on credit issues or issues on consumer protection, insofar as also protection of personal information and access to information is concerned. So we definitely are even ensuring that in our plans this year, we do collaborate with other institutions. With regards to what Jablani raised, Jablani, we have had a number of engagements with other provincial archives such as KZN. We even collaborated with them in our last session, the International Day for Universal Access to Information, and we had a standalone session. We were engaging with municipalities and departments on the issue of records management, access to information, and protection of personal information. So we're definitely open to collaborating on invites. We can come to public awareness sessions, and we can also on invites come and conduct a training. But please do remember the key point I made here, key message. we are very thin on the ground, and we may take your invitation, but we will schedule and we will definitely get to you. But please do send your invitations to us for us to conduct those collaboration. Dr. Nell, thank you so much for raising that. And the important part about age-appropriate materials, it is something that we are still working on and grappling with. There has been even an invitation by a higher learning institution to collaborate with us to create comic books for children and content that children can also understand when we speak about right to privacy and access to information, online harms and safety. So we are definitely open to that collaboration. We'll definitely be meeting and having that engagement, because it doesn't help to disseminate information that no one can actually interpret and understand, which is why I even said earlier that we still want to create more content that is in Braille. We want to make sure that we do have sign language interpretation embedded in our videos so that we really reach everyone. So we're open to those collaboration, and we do welcome it, and we'll definitely be having an engagement. Thank you so much, Chair.
Thank you very much, Ms. Zondi. So we will move. If I may propose, it would be much easier for us to just finish all the presentations, then go for lunch. If we can push as far as that, then everyone can be released on time and do whatever they need with the rest of the afternoon. So I'm just going to request the next coming presentation are really from the support structure of the Information Regulator. So they are not really long. It's just for us to indicate what it is that we do, what is the support that we give to the Information Regulator to be able to deliver on their mandate. So I don't think we are going to be very long. So can I propose then, Mr. Jansen, for you to come forward and give us your presentation. Mr. Jansen is the Chief Legal Officer. He is our executive for legal office. Can we give him a round of applause? And I trust you, Mr. Jansen. I know you don't have too many words.
Thank you, Ms. Zulu. No pressure. Good afternoon, Imalahleni. Thank you very much for having us today. I'm a little bit embarrassed because the legal service presentation is not nearly as interesting to look at as the Educom one, but trust me, the work is very, very involved and very interesting. Just on a side note, while I was sitting, I got a spam call from Meals on Wheels. So I know we spoke about the direct marketing issue earlier. Thank you again for having us. So the legal presentation is not very long, but as I said, the work is very involved. Because of the nature of legal services, it cuts across pretty much the whole information regulator. So we are everywhere at the same time, which is interesting, but of course it does put pressure on us to deal with all the work. So obviously I will not deal with every single aspect that we deal with. I will try and focus predominantly on what is relevant to the public, so what is outward looking. So just briefly, the structure of legal services at the regulator is currently myself as the Chief Legal Officer. We have an administrator, we have a senior manager within legal, and then we have two senior officers, one that deals with the senior legal officer that deals with, for example, contracts, legal opinions and other work, and then of course a senior litigation officer. As we spoke earlier from the presentations from Paya and Popia, based on the decisions that the regulator is taking, people are of course now challenging those decisions. They don't agree and they want the courts to make adjudication on that point. So obviously that's picking up quite dramatically. I did warn you, it's not as interesting to look at as the Educom one. So, as I said, I will focus predominantly on what is outward looking. So, of course, we provide legal support to the regulator as a whole. So, we are in effect the legal advisors to the information regulator. So, but very importantly, what we have planned for the new financial year, which is starting on the 1st of April or the following. Very importantly, and I'll start with these ones because they are probably the most relevant, is as we've done the work, obviously within the core POPIA and PAIA, we've noticed that there are some challenges as the legislation is drafted. So we have undertaken a mammoth task to come up with proposed amendments to both POPIA and PAIA. That process is still ongoing, and of course it flows over into the new financial year starting on the 1st of April. So that process we should finalize by the end of the next financial year, which will then be March 2027. We also have an indicator to finalize what we call the POPIA Rules of Procedure for the Enforcement Committee. I'm not going to speak too much about this one, but in effect, these rules assist the Enforcement Committee on how it does its work internally, procedurally, and of course, timeframes and so forth. I will just speak about some milestones that we've achieved. So the major milestone for us is in the current financial year, we had what we call the Section 112 regulations, commonly referred to as the health regulations. So these regulations are, as I said, in terms of Section 112(2)(c) of POPIA, it relates to how certain responsible parties must process health information. Now, those responsible parties, there's a few examples in the Act or responsible parties mentioned. For example, medical aids, pension funds, and other bodies that specifically processes health information. So these regulations have come quite some way. As I said, it was not an easy document to prepare. We've gone through stakeholder engagement. We've gone through publication to invite written comments. The regulator has considered those public comments and incorporated the comments which we were of the view would add benefit to the regulations. We are now right at the end of the whole process, where we have tabled these regulations in Parliament, and we are also now arranging for publication in the Gazette. So this is something that we are quite proud of to have achieved finally. But as I said, it was a challenge to come up with these regulations, and it was a long process because we had a stakeholder engagement and we also received written comments from the public. There's actually duplication, but once again, it's the three targets that we have planned for the new financial year. As I said, we have the amendments to POPIA and the amendments to PAIA that we are still heavily involved in and trying to fine-tune those documents. And of course, we also have the rules of procedure for the Enforcement Committee to be finalized. I'm not going to go into detail here, but what we want to do is pretty much what I've repeated now, to say that we want to achieve, of course, on those three targets that we've set ourselves for the new financial year. As I said, the targets on the amendments to the legislation is a very involved process. It's not an easy process, and I'm sure there will still be some changes to the documents before they are eventually, in our view, finalized and that we are satisfied with them. Just a few challenges that we've picked up. Once again, the amendment to legislation is not an easy process. It takes a lot of research. Of course, we've picked up problems, in our view, with the legislation. As we do the work in both POPIA and PAIA, they've noticed that some of the sections are difficult to apply in practice. And also they don't always make sense. So the legislative process is extremely complex. Also, because the Enforcement Committee and the regulator eventually making decisions, those are then taken on review in court, and of course the litigation is picking up also quite substantially. And then of course, when we receive litigation, there has to be support from the core functions. So also we have to make sure that when we receive, for example, a matter that flows from other POPIA or PAIA, that we consult with that department to make sure that we understand what the complaint or the matter was about. Of course, if we do not do that, then we are going to possibly take on a defense which will not assist us, or it does not have grounds if we don't consult with that department. Okay, then I just want to add on a few, just a few other very small things. I spoke about the litigation earlier, so I'll just briefly speak about that. As the chairperson mentioned earlier, the matter of the Department of Basic Education, it's one of our high-profile matters. The judgment was handed down in December of 2025. The regulator did not agree with the judgment, so we have filed an application for leave to appeal, which will now finally be heard next week. So we will see what happens there. We are, of course, hoping that the judges will agree that we may actually approach the Supreme Court of Appeal on that basis. Then another high-profile matter which was also mentioned is the matter of Department of Justice that relates to a security compromise that took place in 2021. So this matter has come quite some way, where an enforcement notice and an infringement notice was issued against the department. They have taken that matter on review, so we have filed all our affidavits and replying affidavits. So the point now is to have the matter enrolled. So of course, you can never say with the court process, but hopefully this matter can be heard this year still. And then a last point I want to make also for the general public, just to be aware, in terms of Section 21 of POPIA, I don't think we spoke about operators already, but very important for your sake as well. When you enter into a service level agreement with any service provider, and they might process personal information. In other words, personal information, for example, of your staff or other personal information. You need to make sure that you enter into an operator agreement with them over and above the service level agreement. So please go and have a look at Section 21 of POPIA. That, of course, sets out it must be a written agreement. And very importantly, if there is then a security compromise on the side of the operator, where there's some security breach of your company's personal information, then that operator agreement should cover what happens in such an instance. So that's just some advice or just some guidance that you must please keep in mind. Thank you so much.
Was I lying? He's not a man of many words. Thank you, Mr. Hansen. I will open the round of Q&As. There's a question from Mr. Ndlovu there at the back. And there's a gentleman right in front of him as well.
Thank you. Yeah, thank you for that presentation. I just have two questions. The first one, you said, if I understood you correctly, you said in terms of Section 21, there must be an operator agreement in addition to the SLA. Could you please clarify that? Because when I just quickly looked at Section 21, it's saying there by way of a written agreement, but so I'm not sure if we have the same understanding. But anyway, you can please clarify that. And then the last question I have, when I looked at your structure, I don't know if you can just go back a few slides, if you don't mind. Just sorry to take you back. Just the structure. There we go. Yeah, I'm so sorry to take you back, but when I look at this, I'm seeing a structure that you're litigious from the get-go. For me, it should be respectfully, it should be legal and compliance, because the nature of POPIA, it's not really litigious. It's principles based. So there needs to be that blend in approach where you've got a lawyer who's got maybe like a litigation background, and then you've got like a compliance person who's more risk based, more risk management based. And that comes through in your regulations and certain aspects of POPIA. But if you just have a bunch of legal people with more inclined to box, let's go, let's do it.
Why are we?
And
bunch of
I mean,
layers.
no, 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 no. Listen to me. Hear me out. Hear me out. You know, if you've got compliance as part of your function, by virtue of the GACP, you have to manage compliance risk. That's your job, and just to manage the organization as well from a budgetary point of view. You don't want to fight all the time. You want to pick your battles, and I think that's where that relationship becomes useful, legal and compliance. But that's something you can think about, etc. You don't have to agree. I'm not saying I'm right, but you know, that's what I see. And then the last point is regarding you phrased the interdepartmental dependencies as a challenge. But surely, and I suppose it touches on my previous point, that's an opportunity. You want that interdepartmental dependency so that you can leverage each other's skills. And again, if you're leveraging each other's skills, then you know sometimes there's gonna be a camp that says, guys, let's go and fight. There's gonna be a camp that says, guys, you know what? That's not the right approach. That's not the correct tactic to use. So I would implore you to say that the interdepartmental dependencies, that's an opportunity. That's not a challenge. Thank you.
Thank you very much. Mr. Jansen, you spoke about regulations that you've developed on management of health records. I just want to say this. The Department of Health in Mpumalanga has had a lot of cases regarding personal medical files that are being requested by people, and then they end up with lawyers and everything. Then the department is sued. And in other cases, kunabokoko that are in villages who can't go to the clinic, and they request umzukulu to go and fetch medication for them. And when they get there, they are asked, or they ask for the file of the grandmother. So the regulations, do they cater for such cases on how these cases, or how you regulate in terms of these records being given to people? Thank you.
I think I saw another hand at the back there on the far end at the back, unless I made a mistake. Okay. All right, can we just respond to those two questions, Mr. Jansen?
Thank you very much. Mr. Dover, I see you everywhere at our events. You're one of our biggest fans, it looks like. Just remind me, where do you work again? Where do you work again, Mr. Dover? Sorry? Okay, thank you. So I'll start with Mr. Ndlovu's questions. So, Mr. Ndlovu, regarding Section 21, the operator agreement, obviously it's, I mean, I don't want to now give a lecture, but it says a responsible party must, in terms of a written contract between the responsible party and the operator. How we as the regulator have interpreted it, you have the service level agreement. Well, obviously for the services or the goods that they must render. So we also have a separate operator agreement. Now, obviously, it's open to interpretation. That's how the regulator has done it. Obviously, if there is then a possible security compromise on the operator side, then you can fall back on the operator agreement. That's obviously a preventative measure or safety measure. Now, that's obviously how we've interpreted Section 21 as it relates to operator agreement. Now, unfortunately, I can't take it much further than that. I'm not sure if that assists you. Perhaps let me go to the other questions if maybe there's other follow-up questions. Regarding the legal structure, Mr. Lowe, you said something about what about including a compliance person. Now, this is obviously very operational, but we have someone that deals with compliance in the organization. Now, obviously, they don't feature here. They are under a different department. Now, I'm not sure what your question was here. I think you were just trying to make us aware that it's something that we can consider. But there is a risk function and a compliance function within the regulator. As I said, it's not under legal services. Regarding the interdepartmental dependencies, once again, it's very operational, but when we receive a litigation, a new whether it's a summons or an application, we consult with the relevant department, whether it's a POPIA or PAIA related matter. So obviously we need their assistance to explain how a particular complaint arose, what was the decision. So there is an exchange of information and knowledge between legal services and that department. Now, once again, this deals predominantly with litigation. Now, obviously you fall within your specific department, whether it's POPIA, PAIA, legal, and so forth. Now, we do obviously cooperate with those departments, and they need to assist us to understand those complaints. Because depending on what they tell us and what decisions have been made, that informs our decision as the regulator, how we will deal with the matter. There have been matters that we did not oppose, where there was no need for it. Obviously, there are matters that we need to oppose, and will continue to oppose into the future, depending, of course, what is asked for against the regulator, and of course, depending on what happened in a particular complaint. Regarding the gentleman, I can't remember his name now. Sorry, sir? From archives, yes. Thank you for that. Regarding the question on, and I mean, I know this, I've come from private practice where attorneys want records of patients. Mostly is to submit claims, whether medical negligence or maybe road accident fund claims. So the regulations in terms of section 112 does not deal with that. That is a PAIA-related matter. Now, I don't know how the hospitals deal with these things now. Usually you could write to the hospital, you say you act on behalf of a client, you attach power of attorney, ID, and so forth, and then the hospitals will provide you with the records upon payment. Obviously now the hospitals, I think they've become cautious because they want you to submit the PAIA request. So unfortunately, I can't speak to that. I don't know how the hospitals deal with that now. I haven't been in private practice in a few years. But to answer your question, the regulations don't deal with that question. That's a PAIA-related matter. I hope that assists you. Thank you.
I think Mr. Kwala, Member Kwala would like
Oh,
to assist
okay.
you to respond to that question. Member Kwala, you have the floor.
Yeah, the question from Mr. Jablan. I think there are two problems there. The problem is in the department itself or in hospitals, there are people who are basically engaging in illegal stuff like the touts. We all know that some of the people are full-time touts. They get these files, they give them to lawyers so that the lawyers can have can sue the department, obviously. But I think that one is a different issue that needs police and maybe you guys to be more vigilant in hospitals, who comes there, who does what there. But in terms of a lawyer with a power of attorney from the client, I mean, that's a legitimate issue. I don't see how you could refuse. I mean, if my client gives me an instruction to take the department to court because of medical negligence that would have taken place in the hospital, it's perfectly in order. Yeah. So I think the issue that was subtle in your question is tout, and I think people must deal with touts. It's a problem. There are people who work with ambulance people. There are people who work with staff at hospitals who basically take this as a side hustle. Whenever there's a client who has been involved in a car accident, a tout will take that file, reproduce it, and give it to the attorney, and the attorney will come hounding that patient. Yeah, so I think that's the issue. Regarding, I think, Mr. Ukachen, the structure being litigious, I think Mr. Jansen tried to answer it. It's support here. The legal department gives support. People who deal with compliance and so on, that falls within the core. For PIA and PAIA, they've got that kind of capacity. Here, in most cases, the case comes to the legal department because already people are litigating. And therefore, that's why you find that you must have that kind of litigation capacity. But I'm saying, I think We understand your comments. It could be done better, but to say it's litigious, I don't agree with you. The issues come there already. Papers being served to the regulator, and those papers must be handled. Regarding the issue of calling us a bunch of lawyers, you remind me of, at the funeral of the late, I think he was the spokesperson to the president, the son of the, I've forgotten the name, but he was the spokesperson of the president. So the son of the deceased, he was speaking at the funeral where there was a lot of, important guests, the president and so. And the young man, being a Gen Z, and I looked at you, you don't look like you are a Gen Z. But the young man, because we understand he's a Gen Z, he stood up there and said he was overwhelmed by the number of important people who were there. He even said, I can't believe that even Cyril is here. Talking to the president. So we will take it that probably, the Gen Z habits have gotten into you. So you are not saying that you are a bunch in a negative sense. I think it was just the manner of Gen Z coming out of you. So we'll forgive you for that. Thank you.
Thank you.
Okay.
Done.
Thank you very much. A round of applause for Mr. Jansen. Okay, now we will, without further ado, I'm going to request our CIO, Mr. Luyaba, to take us through the systems, and I am going to be a bit biased in giving him time because these are the systems that will assist you in logging in your calls. So you need to understand all the systems that we have that have been designed by him to assist us to move forward with our complaints. Mr. Luyaba, have the floor.
Thank you, CFO. Good afternoon, everyone. So my presentation will briefly outline the role of ICT within the Information Regulator. We'll look into the strategic focus areas. We'll look into some of the key digital platforms that we've put in place, that we've implemented, as well as our priorities for the upcoming financial year. So we as ICT, we play a role of an enabler. We try to enable the regulator to deliver on its mandate efficiently and securely. Let me emphasize on that, particularly as we expand on our digital services and modernize our systems. The purpose of the ICT division is to basically manage and provide information and communication technology services, ICT for short, for the regulator. And our role goes beyond just the traditional IT support function. We enable the organization's operations by providing systems, providing infrastructure, digital platforms, and that support those that support the regulatory function. Our services or our responsibilities include, I won't go into detail, but they include the management of applications and ICT projects. We ensure strong information security and cybersecurity. We maintain the regulator's ICT infrastructure. We also develop strategies as ICT for managing all of this and governance frameworks. We also support digital transformation initiatives for the regulator and provide technical advice on emerging technologies that may have an impact on the protection of personal information as well as access to information. And lastly, we support regulatory oversight through technical assessments that the regulator conducts, and those include Condition 7. When we assess POPIA on Condition 7, we are part of those assessments. So I won't go into detail on the next slide. It's basically how we structured this, and the next slide is what we do on a day-to-day basis. But at a high level, this is how we structured. We are currently undergoing a restructuring process to align to how we do things now. We've made a decision to change how we provide ICT services. We do that internally now instead of relying on service providers. So we've divided the division into specialized functional areas that ensure that we can effectively support the regulator. We've got the applications management that focuses on developing systems and maintaining the systems that are in place as well. We automate business processes under this function, and we provide application support and testing services for the systems that we do. We've got information security. That function focuses on monitoring technological developments, conducting research. That's information technology analysis. We monitor technological developments, conducting research on digital platforms, and we also provide expert advice on I mentioned on emerging technologies and their implications to POPIA. We've got information security. This is about safeguarding our digital environment as the regulator by managing risks, by monitoring threats, and by ensuring that our systems are protected, not just the systems, but the network and the data as well. These are other units that we've got. We've got ICT infrastructure management, which ensures that all our hardware, networks, and all other ICT infrastructure is properly managed and secured. We've got service management. This unit provides user support through help desk and management of incidents, and ensuring that all our staff members have the necessary tools to be able to deliver on their jobs. And finally, we've got ICT strategy, governance, and knowledge management, which focuses on development of policies, managing our data governance and knowledge management, and these ensure that our ICT initiatives remain aligned to the strategic objectives of the regulator. So the ICT strategic focus is centered on enabling a modern and digitally capable regulator. One of the key priorities that we've got on there is digital transformation of regulatory services, where we continue to digitize and automate our processes where they were previously manual, and we want to improve accessibility of these services and improve on service delivery. We also embedding automation within our business processes to reduce administrative workload and improve operational efficiency. Another important focus that we've got on there is maintaining a secure and resilient digital environment. Given the sensitivity of the data that is handled by the regulator, we need to ensure that it is secured. So that's one of the focus areas that we're looking at. We are also strengthening our data-driven decision-making through improved data governance as well as analytics capabilities. And finally, we continue to develop our integrated systems aligned with enterprise architecture. While we monitor emerging technologies and those that may have an impact on the protection of personal information. But some of the key achievements for the regulator, really not just for the ICT division, has been the launch of the e-services portal by the regulator, which digitizes several external facing services. It was developed internally and allows responsible parties and other stakeholders to interact with the regulator through an online platform rather than relying on manual or email-based submissions. This e-services portal was launched less than 2 years ago, and since the implementation, we've seen an increase in the number of information officer registrations. We've seen an increase in the number of annual submissions. I'll touch on the numbers a little bit later on. With the portal has also improved the quality and consistency of submissions in cases of submissions, and you're able to view data in real time, and it improves transparency and accessibility of our services as well. So this slide focuses on some of the services that we got on there, and I'll take a few minutes just to tell you about some of these services that we've got available. Maybe I should start with how you access these services. You can visit our website, inforegulator.org.za. You may also go directly to the e-services portal by visiting eservices.inforegulator.org.za. We have also collaborated with the CIPC. We now have some of our services available from the CIPC Biz Portal platform. So while you're busy with your company related compliance matters on Biz Portal, you can also then do your regulator compliance while you're in that portal without the need for you to go to a different portal or to register another username in another portal. We are one public entity, public service, and we want to have our systems integrated. So that's what we're trying to do here with the availability of these services on Biz Portal. All right, so some of these services that we've got information officer registration. You can register and update your information officer and deputy information officer details at any time on the portal, and you're able to then generate a new certificate with your updates reflected as soon as you finish, and this is done in real time. We've got per-year annual reporting. I think we all know that it opens around April to June every year, and that will be coming up in the next few weeks. That is catered for on the system. We've got reporting of security compromises. I think we all know that any entity, private or public, is required to report any security compromise to the information regulator. This can now be done online, and you're able to submit all required document on the system, and you get back and forth communication from us until the matter is finalized. We also recently, so the security compromises, I think we made available online around April last year. We have just recently introduced applications for POPIA exemptions. You may now apply for exemptions for certain provisions of POPIA that are permitted by the law. You can do that on the system. We also have some compliance transparency services that we've got on there. We recently, again, very recently introduced online complaint submission for both POPIA and PAEA. So if you've got a complaint against any public or private entity, you may now submit that online on our portal, and you provide us with the details, you provide supporting evidence electronically, and then we take it from there, and you're able to interact with us on the system until the matter is resolved. We also introduced a function that we call iSupport, which is essentially a query management system. So if you've got any query with the regulator, you can log that on the website, and then we log that as a ticket, and it enables a structured tracking of that matter until resolution. And we've tried to improve turnaround times on us getting back to the queries that we get as the regulator. We've got an organization search function. It allows the public, anyone, to search on any registered entity. You're able to view information about it, and such as who the information officer is, are they compliant with our laws, are they submitting their annual reports? You're able to see all of that. Even their PAEA manual, if they've uploaded it, you're able to view that from the website, as well as automatically available records. And lastly, on this section, we've got some compliance checks that are focused at public entities as well as political parties, where you're able to see which public entities and political parties are compliant with the regulator. Now, this is where we normally do some naming and shaming, but unfortunately today I did not prepare a slide on this from Mpumalanga. But when looking at compliance, starting with the provincial government, we've got 7 provincial departments, and we've got 12 provincial departments, and out of that 12, only 7 are registered with the regulator. And when it comes to PAEA submissions, PAEA annual report submissions, only 5 of those submitted for the last financial year. And those that are not compliant include the Department of Community Safety, Security and Liaison, Department of Culture, Sport and Recreation, Department of Economic Development and Tourism, Department of Health, Human Settlements, Social Development, and lastly, Provincial Treasury. All of those are not compliant with the regulator. Similarly, we've got a similar picture when we look at local government. We've got 18 municipalities in the province, and only 11 of those submitted their annual reports in the last submission period. So please, it's opening in a few weeks. Please ensure that you do comply. Those that are not registered, the portal allows you to register. If you have any issues, the iSupport function will allow you to log your query and be able to resolve it quickly. So what I'm sharing with you now is publicly available on the portal. So you're able to log in on the e-services portal, and you're able to see all of this. You're able to see which organizations are compliant and which ones are not. While on key achievements, I'll then maybe mention another portal that we've developed. I think it's another significant development on our side, where we launched the My Regulator portal, which is an internal-facing portal. E-services is outward-facing. We've got an internal-facing portal that is designed to support the operations of the regulator. It provides a centralized environment for managing cases, workflows, documentation across the organization. So through automated task allocation, so when you log a query on iSupport on e-services, or you submit a complaint, it's then routed to this My Regulator system in the back end, and this is where our internal staff work on these matters. So this is automated, and we try to do automated task allocations and notifications to reduce reliance on manual workflows, and this has proven to improve some the time it takes for some matters to be resolved. We've got some real-time dashboards as well that come with the system, where we can provide management with oversight on whatever's happening in our environment. Overall, we think that the platform has improved operational coordination, and it supports better reporting to leadership structures such as EXCO. What do we want to do in the next financial year? So I think we want to continue expanding on the digital services that the regulator offers. Our performance indicator for the next financial year is an addition of 2 different services to our online processes. And for the next financial year, we'll be looking at development of a system to receive and manage applications to process personal information. I forgot special there, to process special personal information. No, it is there. And we will also be developing a system to receive and manage applications to process the personal information of children. Now, how does this contribute towards our strategic plan? I think I can skip through the slide and to try and save time. Most of what I've got on there has already been covered here today, so I'll just go straight to the next slide that deals with some of the challenges that we've got as ICT. While we continue to make progress in strengthening our digital capabilities, there are several challenges that we've got that may affect the pace of our implementation. One of the key challenges there is limited human resources, which affects our ability to support system development, basically all of the different functions that I mentioned earlier. And most subdivisions that you saw earlier, we've got just one person responsible for each of those units. So we are very thin on human resources. We've also got budget constraints, which also impact procurement of critical software licenses, infrastructure upgrades, as well as specialized security tools that we need to have in place. At the same time, the growing uptake of digital services it places an additional demand on an infrastructure and support capability. We've got the cybersecurity landscape that continues to evolve. And I think that requires continuous investment in monitoring and protection measures that we've got. And finally, digital transformation requires ongoing change management and user adoption, and also a gradual migration on the remaining processes that we've got that are still manual, that need to be automated. So yeah, those are some of the challenges that we've got as the unit. And CFO, I think I'll end it there for questions and answers.
Thank you, CIO. And we are opening the floor for the questions. I'm sure you would have a few questions because these are the systems you use to log in your complaints. So it was very clear. I think the CIO, thank you very much, CIO. We appreciate that. There is a bit of a logistical challenge. I know we had said we'll take all the presentations before we go to lunch, but the kitchen closes at 2:30. So I was wondering if maybe we should take lunch and then come back and finish the two presentations. They're not going to be very long, I promise you. Probably I will take 5 minutes, and I know Mr. Lidwaba will take probably 10. So can I propose that we have lunch for about... Okay, let me get direction from my leadership. Okay, so the chair is suggesting that we take all the presentations and then the questions will come after lunch, if you agree.
You are next, aren't you?
Yeah, Angela, you must introduce me.
It's called a coup. It's called a coup. It's not a military coup, but it's a coup of sorts. I will be facilitating this session on behalf of our Chief Financial Officer, who is our Program Director, but she has to present now. So we've arranged that I will just manage this process. So ladies and gentlemen, please, let's show appreciation for the CFO to make a presentation on finances.
Thank you very much, Mr. Dimba. Ours is a very short presentation. Our role really is to ensure that in all the work that the Information Regulator does, we allocate the required resources. So we thought that we should just share one slide just to indicate how much is appropriated by Treasury to the Information Regulator. So the slide in front of you is an indication of our total budget for the year for 2026-27. So it's 140 million. 108 million of it is for the salaries. So it's compensation of employees. And then the goods and services, which is really supporting the work that we do, it has been allocated 29 million. As you can see, it's a very small amount. Given the fact that we have about 60 million citizens that we need to take care of in terms of protection of personal information, you would agree with me that that cannot be done using 29 million. And then the 3.2 million is what we use to assist the CIO to develop the systems. And obviously it's very minimal considering that his plan is very huge and there's a lot of systems that he still needs to develop in place. And this amount has been unfortunately cut recently. And these are the challenges that we face because we have been born at a very difficult time when there are a lot of financial constraints in the country. There are Madlanga commissions, there is ESCOM issues. So every time they cut the budget across the board, we also get affected equally, even though we are just growing and we have indicated that we are only 10 years old. So with this budget, we can do so much, which is why these engagements are very important to us, because then we need to collaborate in certain areas where we can collaborate to do the work together. We all have a lot to gain because we all have data subjects who are our clients who expect service delivery from you, and also ensuring the protection of personal information and also access of their data, of their information as well. So with the little that we have, we would really like to call on those collaborations, which some of you have already indicated that they are interested in, so that we can be able to go far with the budget that we have. So I think I've already narrated what the budget is for. So in terms of the allocation, I've indicated the bulk of it, which is 75%, goes to the salaries for the people that are working in the information regulator. And I think you've seen the structures. We've got about 138 people, if I'm not making a mistake, or 128 people, around 130. So those salaries are for legal, fundis, they are for IT, for everyone that actually works at the regulator. And then in terms of goods and services, I've alluded to that, I don't think I should repeat. So when we look at what exactly, how do we apportion the resources that we have to support all the core functions, which is POPIA, PAIA, EDUCOM, because those are the key activities that we need to look at as an organization. What has been allocated to PAIA is only 22.3 million, and I think they've given you the challenges, the security compromises that are coming in, which we are not able to keep up with due to the capacity constraints that we have. And then in terms of PAIA, we have allocated 16.3 million, which they have to do everything on. And then in EDUCOM, it's 18.7. So you can see that we do have challenges in the financial constraints. I think Mr. Jansen spoke earlier about the fact that they are looking at amending our legislation. And one of the reasons why we are amending the legislation is because we want to incorporate our funding model. Because clearly with the funding that we currently have, it's not sustainable. We will not be able to continue doing our work the way we wish to. Becoming a world-class organization requires a lot of resources. So what we are doing now is we've developed a funding model which is going to assist us to supplement the funding that we currently have. And we do know that it's going to take some time, but with the support of the ministers and Parliament approving the amendments on time, then we can be able to start generating our own income so that we can be able to support and be able to adhere to all the requests that you have put forward. Some of you have indicated that you'd like support from us for training. So in order for us to have adequate resources for training, we need additional funding, we need additional capacity. So that is where we are. So sometimes when we can't reach you, you need to understand it's not because we have no interest, it's because of the lack of the resources or inadequate resources for us to do what we need to do, okay? That is the end of the story of finance. Thank you, Chair.
Thank you so much, CFO. Please just note your questions. We will open it up for a discussion after a presentation on human resources from Mr. Letwaba. So Mr. Letwaba, over to you, sir.
Thank you very much, Mr. Dimba. I'm not sure, I was not sure whether you could still continue. I was expecting Ms. Zulu to continue facilitating, unfortunately. Thank you. Thank you very much. My name is Situpile Dwaba. I'm responsible for human resources management and administration. And good afternoon to everyone. Without a waste of time, we performing administration functions like finance. We do provide support to the divisions to actually continue investigating and monitoring and compliance, as well as rolling out educational programs. In a summary, what we actually doing is just to provide strategic support in relation to human resources and administrative services to the regulator. And in the main, these are the functions that we are responsible for. I'm not going to dwell much on them, just to touch a bit on them. Recruitment and selection, performance management, and other related functions. So this is what mainly we do to support all the divisions that I've presented, to ensure that we continue actually discharging a mandate. I'm now going to move to an area that I think is important. And the reason why are we moving to this area is simple because in the consultation process last year, I think it was in March, we had a question on how are we doing in terms of the implement equity. How we comply in terms of the appointment of people with disability. So the regulator, like any other organization, we are actually mandated to ensure with the national targets of the Implement Equity Act. But in so doing, POPIA as well has a provision to ensure that we advance the persons disadvantaged by the unfair discrimination. That is section 47(3)(a) and B of POPIA. We also, in line with the section 20 of Implement Equity Act, have a plan, Implement Equity Plan, to ensure that we actually comply with the Implement Equity Act. In terms of the plan, we have got two targets. The first target is 2% employment of people living with disability, and the second one is 50% employment of women at the SMS level. In terms of how are we doing to achieve these targets, let me first mention that it's not that they designate as a designated employer, we're only dealing with these categories of targets in terms of equity, but in terms of our plan, we started with these two targets. We'll then obviously review our plan to roll out on other areas of the employment equity. In terms of the appointment of people with disability, I think we've got a challenge here. We are not doing well. We only have 1.5 against the 1.5 employment of people with disability against the target of 2%. And this is an area that we are actually trying to improve. We have put measures which I will explain later in terms of what measures have we put. In terms of 50% of employment of people, women at senior management level, we have actually achieved 50% on a dot. We have actually achieved their targets. And lastly, just to touch a bit on a challenge that is actually affecting us as the country. And I think almost each and every one of us is actually affected by the youth unemployment. How are we then contributing as the regulator in terms of reduction of youth unemployment? Currently, we have appointed 42% of youth between the ages of 25 and 35. So in other words, when we appoint, we also prioritize the government priority on the reduction of youth unemployment. I'm not sure if I'm done, should be the end. This is the last area on the challenges. I decided not to actually capture all the challenges. I captured the one that actually is talking to this presentation, which is the inability to attract people with disabilities. That is the main challenge that we're facing currently, despite all the interventions that we put. I think that is the end of my presentation, Mr. Dimba. Thank you for the.
Please remain there. Don't run. Don't run. I have to subject you to some accountability. Are there any questions, ladies and gentlemen, colleagues? Any questions for Ms. Zulu on the finances and Mr. Ledwaba on human resources priorities? I don't see hands being raised. Means the presentation was, is there a hand? No. The presentation was clear. Thank you so much to our presenters. Now I will gladly hand back the reins to the CFO.
Thank you very much, Mr. Dimba. We've come to the last item of our engagement. I am going to request Advocate Strom, who is the member of the Information Regulator, to give us a way forward from this session. And that's our last speaker. Advocate Strom, a round of applause.
Good afternoon, colleagues. My name is Lebogang. I'm one of the members of the regulator. I would like to thank everybody, our colleagues who are here today. I mean, some of the colleagues are not from this province. They had to drive to come here. So I really like to appreciate the attendance of those colleagues who have traveled from far. Today in this stakeholder consultation, chair of the session on the 2026-2027 APP, our annual performance plan, we had opening the chairperson with the work of the regulator, the CEO, on our operational function as the regulator, and divisional presentation on POPIA, PAIA, EDUCOM, legal, ICT, finance, and HR. We have identified some few gaps on each division's presentation, and we've taken note of it. For an example, in PAIA, best practice and the combined assurance on risk audit and compliance. That was the takeaway in PAIA. I think the highlight was to integrate AI in both POPIA and PAIA, and we are doing so in our work that we have started on the amendment of POPIA and PAIA. And also EDUCOM, Ms. Zondi, the partnership, especially safety of children online, we've taken that collaboration, we're going to take it forward as it is very important. Legal has presented some of the cases, major cases that we're dealing with at the moment. ICT, the CIO, we have presented how far we are in terms of implementation and development of our system. Ms. Zondi, yours was just to give us the money that Treasury is giving us in a year. And I think colleagues have seen that we don't have much budget. From HR, I think the last speaker was Mr. Ledwaba. Thank you, Mr. Ledwaba, in terms of especially touching on the issues of BE implementation in the organization. Now, I would also like to thank the organizing team led by Ms. Shelembe, Ms. Lichwiti, and Mr. Molaba. And we'd like to acknowledge the organized structures, local, Drug Committee, Crime Prevention and Drugs Kulisa, and SEPS, and also the support from the GCIS in Mpumalanga for mobilizing this engagement today. But I would like to further again reiterate that we really take this matter seriously, and we honor and appreciate the attendance from our colleagues. So from me, Lebogang, I thank everybody. Enjoy your lunch. Thank you.
Thank you for being such a wonderful audience. Enjoy lunch and the rest of your afternoon. Drive safely back home.